All right, authenticate your birth certificate. Now you got, you want to learn approximately 250. All right, here. That ain't work. What you do now? Oh, no, you ain't get the embossal. Oh, that's another, I give it to you for 500. All right, I didn't get this money. What's next? Went there, took it to they rejected. Nah. You missed the bond payment. All right, authenticate your birth certificate. Now you got, you want to learn approximately 250. All right, here. That ain't work. What you do now? Oh, no, you ain't get the embossal. Oh, that's another, I give it to you for 500. All right, I didn't get this money. What's next? Went there, took it to they rejected. Nah. You missed the bond paper. Give me $100. I'm gonna send you the special bond paper. Oh, okay. Hey, nothing still.
You're rocking with the best.
Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Oh, I am the blueprint.
You're rocking with the best.
I cannot help that they copy. Hey, I am that dad, call me Poppy. They wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. I created my own school. Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer that's not in remission. Hey, please pay attention. You can't recreate the five lenses. You can't duplicate what is written. You either gon' pay the tuition or pay for assistances. Or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen sink. I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Hey, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it, when I talk classes in session, professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. Set you, yeah, I'm done with this lesson. Came from the streets, still I'm a step up.
All right, authenticate your birth certificate. Now you got, you want to learn approximately 250. All right, here. That ain't work. What you do now? Oh, no, you ain't get the embossal. Oh, that's another, I give it to you for 500. All right, I didn't get this money. What's next? Went there, took it to they rejected. Nah. You missed the bond paper. Give me $100. I'm gonna send you the special bond paper. Oh, okay. Hey, nothing still happened. No. See, we gotta dye the bond paper. It's a special dye that you gotta put on the bond paper. Oh, how much is the bond? Oh, that's only $175. It's a special dye because when they touch it, like it gotta process through the scanner in the system in a special way, the secret way. Okay, here's $175. Nothing happened. No, because you were supposed to put it on the tax form. You never said. I did. I said, remember, once you get all that stuff, you might have to come back to me for the taxes. You don't remember? I sent you the text. I didn't get no text. Oh, look, I've been dealing with so many people. Hold on, let me go ahead and type it up right quick. And then making sure like I didn't send it. I'm just gonna leave it in the box, but I'm not gonna send it. Hold on. See, it's right here. Oh, see, look. It never sent. I forgot to send it. Oh, well, how much is for the tax? $600. I'll do the tax for you. All right. Boom. Get it? Bam. IRS response. Courts have considered claims like yours to be frivolous. Look, we don't have to go find.
With the best.
When you are facing foreclosure, you are desperate for a lifeline. That is exactly what predatory companies count on. They sell expensive securitization audits, claiming a loophole in your mortgage paperwork can wipe out your debt or magically stop a foreclosure. It is a dangerous lie. Federal agencies warn these audits have zero legal standing in court. Scammers pocket thousands of your hard-earned dollars up front, leaving you with useless paperwork and less time to save your home. Securitization audits are not admissible in courts because the authors will never come to court on your behalf and swear under oath to its veracity. Another thing, everything you need to know about your loan, such as the owner, the investors, the pool numbers, can be provided to you through a qualified written request. Even still, Knowing where your loan is does not obstruct the lender's rights to collect or the servicing of the loan. Court requires more than an unsubstantiated audit and the location of your loan. Securitization is legal and highly regulated. Notice of its potential sale or transfer is given to borrowers via the deed of trust or mortgage agreement. The New Culture Empire will break down a particular audit to show you the realities. If you received an audit, you might want to stick around. Do not buy the hype. Protect your home and protect your money.
You're rocking with the best.
Welcome to I know. You're facing foreclosure for whatever reason. You scroll across TikTok or any other social media app and you stop because it said, if you're being foreclosed or if you're being foreclosed, psychologically you stop. I'm in foreclosure. And then the classic emotional grabbing buzzwords. Your loans may not have been transferred properly. The lender may have committed fraud. They didn't transfer the loan into the remit inside of 90 days. You don't have to pay. You're not the debtor. You're the beneficial owner. And the borrower hears, this can stop me from being misplaced. This can stop the house from being taken. This is all they hear. Being the beneficial owner, being, the legalities, the technical words that they use, they don't care. What they hear is, you don't have to pay. The whole process was a sham. And as a result of the process being a sham, regardless if you're in default or not, you don't owe anymore. That is what the securitization audits promise. But what they don't tell you about these securitization audits is that all of the minuscule of accurate information that's contained in the audit, you can get the same information from your servicer, such as who owns the note, the name of the trust, the pool number, but the name of the trust, who owns the note, the pool number. Ask yourself, homeowners, what does that do to obstruct or prevent them enforcing my obligation to pay? You got to ask yourself that. Now, the answer cannot be, well, because I'm the real creditor. No, let's just put that to bed, because if you were the real creditor, you wouldn't have filled out the application. You just would have bought the house outright. So let's just stop there. Now, ask yourself, if I'm in front of a judge and I have this securitization audit, what is your explanation to the judge that will preclude the lender from foreclosure based on the audit? Another thing, did you ask yourself before you purchased the audit? Did you ever see if the audit was actually admissible in court? Because from the hundreds of audits that people sent to me over the years, there's never any person that came back and said, I had court today and I had my expert witness come testify on my behalf. These securitization audits are giving homeowners a false sense of confidence and comfort, because they always seem to purchase these audits and then they sit on them, because the audits to them is a evidence that you don't have to pay. You don't owe. You may be entitled to something, but that reality is only the reality in the borrower's mind. So one of the biggest things about these spaces when it comes to these audits, it was a big money machine. It was a big money machine in the 2010s, early 2010s, when the aftermath of the mortgage bubble, that crisis. And desperate homeowners were paying thousands and thousands of dollars for these audits. But when you start to break inside and break apart these audits, and if you read them in its entirety, you will start to see that is within these audits the hallmarks of a sovereign citizen-like argument. Now, we have a legit audit. Now, I redacted the personal information. I redacted a lot of stuff because to keep the identities of who sent it to me private. But I have a legit audit. Well, not a legit, but I have a real audit. And we're going to dissect this audit. And this is part of the awareness that there is nothing in a securitization audit that me personally, I can't find out on my own. Because what a securitization audit cannot prove what I can prove on it. What we went over in court yesterday. There's no audit that I've seen that we even have that type of conversation. So not only has the government shut down these audits, let me see. Let me just make sure I find out. The government has shut these audits down. By the way, these companies that ran these audits for fraudulent activities. And another thing is the courts are not going to even admit these audits into the record. As a matter of fact, as soon as you see an audit, the attorney sees an audit on the record, they're going to file a motion to strike it, because the proper foundation, just like we will argue that the one who's tested doesn't have a proper foundation, because they're never going to show up to court for you, because it's never produced by an attorney. An attorney's not signing it. You don't have an attorney or a person that worked on Wall Street for 30, 40 years who've managed billions of dollars in securitization transactions. See, that will qualify as an expert witness. So what they're doing is they're putting a bunch of templates together, going on sites and finding generic information that you can find on your own and selling it back to you for thousands of dollars. This is why when you have a securitization audit, you have nothing. It means nothing in court, and it doesn't stop a foreclosure. So it's part of my consumer education series, and this is one of the many series. As you can see, the consumer education series, volume 1, is coming out. This is part of the volume 1. I actually have my accounting weekly. You know, you got the little weekly bulletin news, like little newspaper, like few pages, and I've created that, and it's especially with the accounting side, basically is keep you updated with the new changes, the new laws, the new regulations, the new accounting standards, like a news week, like a weekly bulletin, you know, just to keep you up to date. I have the litigation news weekly. It's kind of like the magazine, but not so many pages, and it updates people on new cases that just came out that may affect, you know, important cases that just came out. So it's basically the Supreme Elite team basically has the consumer education series. These are pretty much I wouldn't call it a book, an ebook, but I call it like a news weekly, like a little publishing, like a little articles, things like that. Yeah. So that will be on the press, where you can subscribe directly to me for it, and you can get your, you know, reoccurring news weekly series, just to keep you up to date, keep you abreast of what's going on, because people have everyday lives. They don't have time to look for it. But this is, you know, my field. So it's my job to stay up to date on current law and current regulations. It's my job to do so. You don't have to do it. I have to do it. So the benefit is you stay up to date with current information, accurate information, relevant case law. And the benefit is I get paid through monthly subscriptions. So the work is already done for you. It's an equal trade-off. So the securitization audit scam, a field guide to homeowners, what these audits are, where they came from, and what courts say about them, and what real analysis looks like. Companion document to my live stream. It's the one for today. Educational materials are for general audiences. No legal advice, no attorney-client relationship is created. The sample audit discussed has been fully redacted to protect the homeowner who received it. What a securitization audit is? A securitization audit, also sold as a forensic loan audit, chain of title audit, or Bloomberg audit, is a document marketed to homeowners in default or foreclosure. Can we pause there for a second? I just want you to take a step out, because you may be in foreclosure right now. You may know someone's in foreclosure, or you probably experienced this before. But if you look at the targeted audience for a lot of these companies and a lot of these, you know, people that has things for sale, if you look at the target audience, if you notice a trend, the audience is always targeted to individuals who don't really have the time to sit back and make a well-informed decision, because they either got a foreclosure looming, a repossession looming. They always got something looming where they kind of got to just go off ear, what sounds good to the ear. That marketing to people, that what sounds good to the ear, has made people massive amounts of money. Now, it is a document marketed to homeowners in default of foreclosure, typically for several hundred to several thousands of dollars. It promises to prove that the party foreclosing has no right to do so. But one of the things that these audits always miss, it's always missing their sales and contributions agreements, is always missing the internal agreements that they have with the owners, which gives the servicer the right to foreclose on their behalf, because they're not privy to that information. And that information is not even filed publicly. So whether they have a right to foreclose or not, it's all going to come down to the court side of things, not what an audit produces. And usually because the loan was pulled into a mortgage-backed security, and that the homeowner can use the audit to stop the foreclosure, void the debt, or even collect from hidden bonds and insurance policies. The sample review for this presentation, fully redacted to protect the homeowner, is typical of the genre. It mixes a handful of real, checkable loan facts with fabricated bonds, invented insurance policies, misquoted regulations, and a quote-unquote action plan of filings that courts uniformly reject. And this report I comprised of is taken from the audit, but that audit, I've seen different variations of it. And I find it very interesting. It really tickles my twine how all these audits action plans has people doing everything that the courts have said you can't do. It means nothing. Where these audits came from, because if you were in my mortgage justice class, which we got a new bonus video for that class coming very soon, just finishing the editing, you will understand that before I even get into the subject matter on what the class and the webinar is about, we're always going to go back to the origins of where we came from in a particular topic, so you can know where you came from, so you can know where you're at today. So in the mortgage reality class, we went back to the inception on how mortgages have morphed into what is known today. And without purposely doing so, by going over the inception, by backing it up with actual professionals, while backing it up with actual real sources of information that you can check on your own. When we followed the timeline, that within itself killed damn near every theory or every talking point about mortgages online today without even purposely trying to do so. The genre has two parents. TikTok, what's going on? TikTok, what's going on? YouTube, what's going on? What's going on, YouTube? The genre has two parents. The first is the sovereign citizen redemption movement of the 1980s and 1990s, which taught that each person has a hidden commercial straw man, that debts could be discharged through UCC filings and acceptance for value, and that signatures create money, known today as the vapor money theory in court. So if you go to court today, and I may not be saying the way that you would say it, but any variation of the sorts of, you only loan me you loan me credit, not money. My signature created the note. Show me the note. I want to see the wet ink signature. I'm the real creditor. I'm really the beneficiary. No, I'm really the investor. Anything, any variations and anything that spawns from that, the courts have packaged those arguments and any variations of those arguments, even if you're not actually saying it, but you're hinting to it, they're going to call it the vapor money theory. Now, you can look up the term vapor money theory, And you're going to find a plethora of both state and federal cases where homeowners have relied on such arguments or variations of, and the courts uniformly, all in unison, that said those arguments are not sufficient enough to withstand a Rule 12b6 motion or a motion for summary judgment or to defeat a foreclosure. These are one of my key sayings. If you don't want to hear from me, I'll let the judge tell you. It is those arguments that makes these spaces dangerous. Legitimate arguments in foreclosure defenses, I mean, those are the arguments that you need to make. I'm not going to promise guarantee wins because there's a lot of facts and circumstances, and you got the human side of court that goes into it. But at least you won't be making arguments that have already been rejected from the door. I'm okay with any outcome on arguments besides the arguments that have been rejected for 40 years. Any arguments outside of that, I'm okay with. Now, federal courts were sanctioning these theories long before the housing crisis. In one well-known 2005 California case, a court sanctioned lawyers for pressing the vapor money claim and described the litigation as a scheme preying on distressed homeowners. Yes, we actually do our thorough, in-depth research over here, because these were these arguments started from. So in the aftermath of the 08 crisis, it was the lawyers who brought these securitization claims, these remit claims, and in the beginning with the fallout with the banks, the courts were kind of entertaining these arguments. But by the time 2010, 11 came around, the courts said, because the landmark case that kind of spread throughout the whole United States and federal courts, just how we look at other courts' rulings to kind of gauge the landscape, that's how other courts do. Courts look at other rulings by judges and be like, you know what, we're going to adopt that ruling over here. This is why the landmark case that shut down Galaski, that shut down Ravenowski, that shut down all post-Phyllis Horace versus LaSalle Bank arguments, and every single securitization argument afterwards was Irabobo 2. That was, even though it was a state California case, many states all got in line and got behind that holding. So now today, anytime you make any claim that's related to a pooling and servicing agreement, that's related to their transfer to the REMIC, that's related to anything that has to do with the securitization process, dealing with the investors, dealing with the trust, dealing with the lender, the courts, their reasoning is the borrower in raising those claims, they are attempting to assert rights in which they don't have, because they were never a privy to the contracts establishing the pooling and servicing agreements. Remember, with the SEC, there is no phantom investor. Either you are a registered beneficiary, recognized, receiving monthly dividends on principal and interest collections from the underlying mortgages, and they're in electronic form, also called self-liquidating paper, in electronic book form, and you are receiving the dividends from your investment. You are not an investor. That is different from saying the substance of the transaction. You can make the argument in substance that you contributed to the capital of the trust. But even still, many people, because of the literal interpretation when they hear words, they really believe they are an investor. And from a legal standpoint, that argument will never get you through the door in a foreclosure or a mortgage dispute. You will never win that argument. As a matter of fact, they're going to put the sovereign citizen label on you for the argument, regardless of what your evidence or what your teachers or what your research came up. So once Irabobo 2 came out, every securitization argument after that pretty much fell to the wayside. And in these spaces, many people who argue mortgages, they're still arguing it from the 2006, 2007 through 2010 way. Because as I mentioned with my news weeks and my weekly journals, they haven't became up to date and current with their research to know what's good law, what's not law, what changed, because the system's often changing. The whole accounting system went through a major overhaul as a response to the 2008 recession. This is why when people still cite FAS 140, is like, that's been discontinued. They use a whole new standard now. And the system is always changing and evolving. So if you're going to take this seriously, you have to stay current. You can't just sit on 5-year-old methods. You always got to refine. You always got to retune. You always got to see what's new, what's work, what can we do, what we can't do. Now, the second parent, is the 2008 foreclosure crisis. Genuine industry scandals, robo-signing, lost note affidavits, sloppy assignments created real public distrust, in the industry of audit mills grew up to monetize it. So based on and these were real, robo-signing, that's around 2008, 2009, fake lost note affidavits, sloppy assignments. And that's what created the audit mills, audit them, securitization. They sprang up around that time. You notice securitization audits started right around the foreclosure crisis, the mortgage crisis. It started right around there. That's where it popped up. And you had hundreds of these floating around. And it's not uncommon today for me to run across a defaulted borrower, and one of the files it's so common that I already know they're going to send it to me before I even say anything, before they send it. They always have a securitization audit. I mean, it's kind of like that's the go-to. In default, go grab an audit. Now, let's get back to it. By 2010, the reaction from regulators was unambiguous. The Federal Trade Commission issued a consumer alert on forensic mortgage loan audit scams, a warning federal courts were soon citing in published opinions. So I'm not just coming up here to refute audit. I do my research. I go back to the origins. Where did this start from? And all the trends pointed to around 2008, 2009, the securitization, forensic audits, or mortgage audits were popping up left and right across the United States. But the connection that you have to make is, how did this audit prove my case in court? The audit never says anything about the borrower signing the note and your obligation to pay. They already warned you on the deed of trust that they may transfer the note one or more times. And just because you don't have a contract with the transferee, you got to go back to your state law. What does the state law say about enforcing a note? Who has the right to collect the note? What does the state law say? Remember UCC 3? They always like to cite it, but I don't think they ever read it. They only cherry pick the most common and popular sections of it, but they don't really read the state laws version, because if you read the state laws version, a holder in possession of the note, a non-holder in possession, a holder in due course, a non-holder but with the rights of a holder in due course can enforce the note. And the entitlement to enforce the note can be transferred by delivery alone. Possession alone allows you to enforce a note. Filing the financing statement listing the note at the UCC1 doesn't defeat my standing to collect because I have the possession of the note. It's more superior in the court's eyes than filing a financing statement. Think about it. Let's get off the legal. Let's go back to everyday real life. If you found a check that had $1,000 on it and it was already endorsed, you just so happen to find it in the parking lot and it was already endorsed, right? You would still be able to cash that check because you're in possession of it. Remember? What do they tell you to do before they cash your check at the bank? We done it so common that you get your check, all right, turn around, sign the back of it and go. But we never really understood why they had you do it. It's the same thing with an endorsement on a promissory note, because it converts the note into a bearer instrument, meaning the person who's holding it is entitled to payment. Prime example, and go back to the example. You found a check worth $1,000 and it's already endorsed. It converted that negotiable instrument into a bearer instrument, meaning whoever's in possession of it can go cash that check. There's no difference between that and the check and the promissory note. So when they endorse the note, it converts it into a bearer instrument, meaning whoever's in possession can collect. A securitization audit does not defeat none of that. It doesn't even remotely can defeat that. Has nothing to do with it. So it's another X against securitization audits. Now, the Federal Trade Commission issued a consumer alert on forensic mortgage loan audit scams. A warning federal courts were soon cited in published opinions. And California's Attorney General, Department of Real Estate, and State Bar issued a joint warning calling forensic loan audits a phony foreclosure relief service for which there was no evidence of any foreclosure relief benefit, even when performed by licensed professionals. And trust me, I try to find successful audit wins, foreclosure wins with that audit on the record. But what I did find was motions to strike the audit and that motion being granted because it didn't comply with the exception to the hearsay rules under the business records, because that's pretty much what you're when you produce an audit, it's just like the lender producing their business records in court. Now we get into the court rules of procedure. I know it's as humans and being, not having a legal background in this stuff, it's not uncommon for us to tend to rely on what we believe is the right way. And that's the difference between the professionals and us. They know the legal standard where they can measure whether what they're doing is correct or not. We have to learn that standard. See, they already went to school to learn that standard. We have to learn that standard as we go. So without full understanding of that standard, we tend to believe what we came up with, what we got, what we feel is the right way to go. And since it hasn't been repetitive to us to always search the court rules, search the rules of procedure, to always make sure whatever you're trying to do is in line with the standards, we kind of, I'm not saying people do it on purpose, but people just disregard that because it's not something that's spinning in their heads that's reminding them to do. So they think that evidence alone is good enough, not knowing that the evidence has to be properly established, admitted, it has to be acceptable to the court under the rules of procedure. We think just because we got evidence, that's enough. Here, slap a SEC file into my lawsuit, and then there you go. Here, print out their 8K and 10K and just attach it to your complaint and just go file it. And there are some people who have admitted that the court rules and procedures are too confusing to understand. So they want to find a quicker and alternative manner, an alternative method. This is where you have the birth of the administrative process, where people will ride that administrative train to the fucking transmission falls out of it. Not because there's real success the administrative way, it's because to them, it's a better alternative than going into court. The largest auto mill, Certified Forensic Loan Auditors, LLC, was ultimately shut down by the Consumer Financial Protection Bureau. It and its principal were permanently banned from providing mortgage assistance relief services with a $3 million consumer redress judgment. The product being sold today under new company names is the same product regulators banned with new decorations. That's all it is. That's all it is. There is no securitization audit, and I'm speaking personal. There's no securitization audit that's going to provide me the information that is valuable in court that I can't get on my own. You don't really need to know the pool number. You don't need to know the pool number. The servicer will give you the name and the pool number, but that's immaterial. Because who owns the note is immaterial in court. Because the person who you're dealing with, that's the most important, who is asserting their right to enforce and collect. And from a foreclosure standpoint, even if you get into judicial default, like my loan depot client, disclaimer, they was already in judicial default before they got to me. But even still, a judicial default doesn't automatically grant them judgment on unliquidated damages. So even though they're in judicial default, people were asking, well, how are you still in court? Because they still have to prove the unliquidated damages, aka the principal balance due. There is no securitization audit that's going to be able to break down the numbers in accountants like I can, so that it's useless to me. The sovereign citizen rhetoric, decoded. These audits can be identified by the vocabulary. Each phrase below appears in the redacted sample that has a traceable origin in the redemption movement doctrine. Yes, I've studied the sovereign citizen movement and its variations dating back to the 1980s. This is why people, when they adopts, such beliefs, and they don't know the origins, because they look at, I'm with this class today, I'm with this person today, this is what I'm learning today. they're not going back to do the origins. So they don't really understand the origins of what they believe in. So when they hear a person like me saying, "Oh, that's sovereign citizen," they're thinking, "No, it's not sovereign citizen today. It's just me standing on my rights. This is the law. This is what it is." But they're oblivious to the 40 years of people who's raised the same claims and variations of the claims before them. But since like the woman that was on the panel with me and Darren, like almost like 2 weeks ago, which I became the subject of a live stream, was that when she was trying to explain her remittance lockbox process, she don't understand that I was on a live stream with a person who was saying the same thing, the remittance, the lockbox. So when I said, "Ma'am, I already know what you're saying. I've heard it before." You notice how her response was, "No, no, 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 no. I did my research. No, no." Because in her mind is, I found the Holy Grail. I found something that nobody else knows. And that's another problem in these spaces. Everybody wants to be, known for finding something out that nobody else in the world knows. When you can go to the Proverbs in the Bible and hear them talking about the same things that will apply in today's time. The term, "there's nothing new under the sun," it's not a soundbite. It's a reality of life. Phrases that are in the audit. And these are actual real key phrases that were in the audit. These are real key phrases. Let me take a chance to acknowledge what's good, Derek? We said, "In default, send a silver dollar." Right. He said, "I like, dance, and subscribe. I like and subscribe." Hey. What's going on, y'all? A debtor and debtor alone. A bearer instruments of liabilities of the debtor. What do he say? Or the creditor or the debtor and debtor alone. Yeah, I got to share from read from the big screen, so I'm going to be back in checking the comments. So taken from the real audit. These are the words. You are not a debtor. You are the creditor. Your signature created the value that was stolen. What it actually is, that is the vapor money theory, the redemption doctrine. Courts have rejected it in every reported case and sanctioned parties for filing it. But that is what's in the audit. And the phrases in the audit, I don't even need to see another audit to understand that sovereign citizen rhetoric, because I could go back to the early 2000s for people who started their case. "I'm a private American national living on the land of the indigenous," saying the same thing. Yes, 98% of what you hear circulating online today in the theories and the rhetorics, I can find case laws from 15, almost way back as 35 years ago, where people are saying the exact same phrases. The difference is, back then, they were admitting in court that they were a sovereign citizen. And for my critics and detractors, in the 1990s, they were telling people, if you're called a sovereign citizen, you might want to respond within 1 of 3 ways. You might tell them that there's no such thing as a sovereign citizen. Or you might want to say, you can't be a sovereign and a citizen, because in fact, you can't be a citizen if you're sovereign. I remember reading that word for word. And number 3, and since a sovereign citizen is a double-minded man, a sovereign citizen is an oxymoron. Fast forward to 2026. Every time I tell somebody in the comments that sovereign citizen rhetoric, they respond 1 of the 3 ways. So to them, they're telling me something. But the way I see it is, I've already heard those responses, seen those responses from documents from the 90s. So that lets me know you didn't even come up with those responses on your own, although you think you did. You think you did, but no, you really didn't. Second one, judges carry fealty bonds, FEALTY. Oaths are commercial contracts, and you can serve a notice of claim against the bond and affidavit of default. What it really is, pure sovereign citizen invention. No such bonds or registries exist. Bond claims against judges accomplish nothing except documenting harassment of the court in your own case. Remember, these are taken directly from the audit. Another phrase in the audit: file a UCC-1 naming yourself secure party over your own note. This is in the audit. What it actually is, the secure party creditor scheme. False financing statements invite expungement, slander of title liability, sanctions, and in some states, criminal charges for false filings. You might want to ask the great white hope, Chris Hauser, how that worked out for him, who was currently in a Tennessee Department of Corrections. Another phrase in the audit: hyper-specific but unverifiable identifiers. Bond policy numbers built from an attorney's bar number, placeholder EINs, and a $250 million apocalypse policy. This is what this person paid for. And why is this dangerous? Because when the borrowers actually file their qualified written requests, they're going to be, some of the requests is going to be related to what the audit said. But what it really is it's a manufactured precision. Real identifiers, a pool number, a MIN number, are woven together with fake ones so the document survives a casual spot check. Detail: the fake identifiers can never be verified through the registries the audit itself cites. This is how you get the CUSIP numbers with the red arrow, in which that arrow was taken from a legitimate financial report. Because when you go and take that CUSIP report and go screenshot it and hit the Google lens and factor in on that arrow, you're going to see that arrow pop up in 100 different cases that got nothing to do with that site. So they take that little arrow and those little graphics at the bottom, they transpose it on the CUSIP audit. They go find a real CUSIP number, place that on the report, and then they create the name of the fund, because when you run the CUSIP number versus the name that's on the CUSIP report, the real fund's name never goes back to the report that you just purchased. And the numbers are created. They create those 150 million, 250 million. They type them in on their own. People take that CUSIP report, then go file tax forms such as 1099B and 1099 OID based on a CUSIP number that has nothing to do with their transaction, and created fake numbers. Feeling the embarrassment from that, they will be like, nah, it's real. But if you ask them, where's the $278 million at? Knowing that they haven't received it, knowing that they received frivolous filings from it, they're going to come back and say, oh, it's private. I don't want people to know my business. But if you run the last year, they're so quick to tell about every little thing they're doing in their life in these space. I found this. I found this. I did this. I did this. Now, when it gets to the 278 million, now they want to move in silence, but they don't mind telling everything else. Right. Now, trust me, I understand. I'm not being difficult. I really understand. Trust me, I understand. I understand the pressures of being right. No, trust me, I understand. What courts say in their own cases. I even provided what the courts have to say about these audits. So this report, if you're interested in a copy, shoot me a DM, or you can reach out at thomaslegacy603@gmail.com. TikTok, if it's a DM, thomaslegacy603@gmail.com. If you're interested in a copy of this report. D'Amelio versus Citizens Home Loans, Inc. Case number 312 CV81, January 29th, 2013. A Georgia federal court dismissed a homeowner suit built on a purchase certified forensic loan audit. The court wrote that it was astonished by the plaintiff's audacity and asking the court to scour a 45-page audit in place of pleading actual facts, and found the audit supplied none. Now, this is one of the hallmarks of these social media lazy gurus who don't even really understand the things that they teach. If you watch or heard my live stream yesterday, I took their own filings and admissions, and you could see I highlighted certain parts, and then I created an exhibit summary, meaning the judge don't really got to look at all those filings, those pages. I got an exhibit summary that references the highlighted portions. See, what they'll tell you to do is go on the SEC, print off their filings and attach it to the lawsuit and just file it, expecting the judge to read 323 pages to try to figure out what they're talking about, when it's your job to already understand why you attach these exhibits, how it applies to your case, and how it supports your substantive claims. But no, that's not what they're going to tell you to do in these spaces. Because the ones who's telling you to do it, they don't even know why they're telling you to do it. It's just passed along, passed down. This is just what we're supposed to do next. In reference, Norwood bankruptcy case from October 25th, 2010, Northern District of Georgia. And why are these Georgia cases, these first two are Georgia cases? It's because the homeowner lives in Georgia, which is a non-judicial state at that, which is the subject of that satisfaction of lien that was in a non-judicial state. And no, they don't have to file a lawsuit to foreclose against you in a non-judicial state. So you can tell how many elbows I had to twist at Navy Federal. And the follow-up phone call with Navy Federal is on YouTube as well. Georgia bankruptcy court rejected audit-based arguments, pointed to the FTC's consumer alert on forensic mortgage loan audit scams. A federal court citing a federal consumer protection warning about this exact product. And the CFPB versus the most popular at the time, certified forensic loan auditors. Stipulated judgment. The federal consumer regulator sued the leading audit seller. Result, a permanent ban from the mortgage assistance industry, a $3 million redress judgment, and a civil penalty. The flagship product of this industry was adjudicated a consumer protection violation, not a litigation tool. So they stipulated that a certified forensic loan audit is a consumer protection violation, not a litigation tool. What you see today is the same shit under a different name, which is still a consumer protection violation, not a litigation tool. So in essence, you are purchasing a consumer protection violation and not a litigation tool. Francis Kinney Family Trust. Every time I see that heading in a court case, the first thing that comes to mind is Sovereign Citizen versus World Savings Bank, Northern District, California, 2005. Just in case you're keeping score, 3 out of the first court cases that had years were 2013, 2010, and 1 2005. 2 out of the 3 years was at the apex of the mortgage crisis. A federal court sanctioned attorneys for filing the vapor money theory. Your signature created the money, so you are the creditor doctrine that closes the sample audit, describing the operation behind it as a scheme targeting distressed homeowners. And that's why I started to see the trend. 98% of people who had an audit were distressed, feeling the pressures of an impending foreclosure. Regimen versus Deutsche Bank, another big case out of the Second Circuit, 2014. The Federal Court of Appeals held and these are the cases that the guy on Facebook wanted to cite. And he cited the trial court. And I sent him a D. I said, bro, did you read the appellate court? The response was, I don't need to read the appellate court. Yes, I was dumbfounded. Okay. Well, this is what the appellate court said. A federal appeals court held borrowers are not parties to the securitization agreements and lack standing to enforce them, closing the door on the theory that defects in the pooling process voids a homeowner's own loan. This was 2014. So when you hear these same arguments online in 2026, I don't know. You fill in the blanks. You finish the sentence. When the people that's online teaching it, you finish the sentence. You put a period on the sentence. You, and yes, YOU, versus JP Morgan Bank. State case, 293, Georgia, 67. What year? 2013. Georgia Supreme Court held the holder of the security deed may foreclose even without holding the note. That is 100% universal amongst the states. Want to know why? Because I can purchase the note. I can send the note over there to be stored, but I can hold on to the deed of trust. Want to know why? Because if I actually sold that note that's sitting stored over there, the mortgage will actually go with it. Well, how can you foreclose with the deed of trust without actually owning the note? Want to know why? Because if I'm in possession of the deed of trust, that means the note was already sold to me. Meaning, the mortgage follows the note. Carpenter only said, if you sell the deed of trust without the note, then it's a split. But if I sell you the note, there's not even a conversation about whether the deed of trust goes. It goes with it. Because that's the security supporting the payment on the note. So when I sell you the note, the deed automatically goes with it. That conversation kills. It kills the online conversations right there. Which means the original wet ink note strategy at the center of these audits is dead on arrival under Georgia law. Real dangerous. The money is only the first loss. Charging homeowners upfront for foreclosure relief services violates the federal Mars rule, the same rule the CFPB used to ban the industry leader, and the purchase price is rarely recovered. The clock is the second loss. Foreclosure deadlines, answer dates, sale dates, confirmation windows, loss mitigation cutoffs keep running while the homeowner mails notices to fictional insurers. The audit's rituals consume exactly the weeks the real case needed. The filings are the third loss. A UCC1 self-filing and bond claims convert a sympathetic defendant into a sanctioned one, and in some circumstances, a criminally exposed one. Judges recognize this playbook on site. It's what they recognize. So when I say DOA, dead on arrival, in 2026, you're probably like the 15,000 filings that they've seen of this. I mean, all these cases at minimum are 12 years old. So you coming right behind them in 2026. And that's the dangerous part, because you think you just discovered something so groundbreaking and new. All you did was just recycle the same things that have been rejected by the courts. And this is what I try to aware people of. It's bad enough navigating through the nuances of court and understanding how nuancey it can get. But when you're presenting claims that have been rejected on their face time and time again, you're pretty much committing, I'm not going to say the word, but you're doing it to yourself. And since we live in a human world with human psychology, somebody has to be blamed for this. We are always usually the last ones we blame. So it's human nature to find someone to blame for my own errors. And this is why I Got Scammed came about. I mean, the scammer can only receive money in these spaces, in this context that you give them. You got to question yourself. What made you pay them? What was it that you heard? Because I've said this before. The hallmarks of a scammer is telling you everything that you want to hear. The hallmarks of its victims are hearing what they want to hear. And with this debt elimination culture, once somebody hears, I don't owe anymore, I don't got to pay, this is going to stop the collection, they stop listening. They're sold. They're psychologically sold. And this is why they strategically market these things as debt elimination. Look online. If you go on these posters in these space, everything it's either free money, free return from the government, no accountability on these contracts you sign, you don't got to pay for it, and you can still keep the property. It's a fraud. You can keep it. You notice that's the number one pitch. You rarely ever see pitches that deals with understanding systems, understanding how the system works. Credibility is the loss that can't be undone. The moment an audit like this is attached to a filing, every legitimate argument in the case is read through it. Homeowners with real winnable servicing claims have lost them by stapling a fake audit to the front. That's a fact. The contrast, what legitimate analysis looks like. Here's the standard our team applies, and the difference is visible in a single sentence. A fake audit tells you about documents no one can produce. A real analysis is built entirely from documents the other side already produced, such as, if you need a, such as things like this, building the record from what Loan Depot already filed, highlighting these highlighted parts, property preservation, corporate advances, these breaking the numbers down based on what they filed, actually commencing an audit based on the record. See, I don't need to go get a forensic audit. I don't need to say, all right, go get an audit and come back to me. No, I'm going to audit the record because the record is the only thing that matters, not a forensic audit. The record is the only thing that matters. So when you get things like this is an audit, my audit on the record. Component per plaintiff's exhibit 5. Component per plaintiff's exhibit 5 as of June 11, 2026. The component adds to the stated total, and the per diem of $53.14 corresponds to the note rate on the stated principal balance. The contested components are the escrow advance, the fees, the late charges, and the corporate advance balance, $43,446 in the aggregate, together with the attorney's fees sought separately. Schedule 7. 4 late charges were assessed between May and August 2024, each against the installment due date of May 1st, 2023. 12 to 16 months after that installment came due, and no others before or since. Even $77 was audited. Hold on. 12 to 16 months after the May 1st due date, you charged $77.53 on May 16, 2024, the same on June 17, 2024, the same on July 16, 2024, the same on August 16, 2024. And this total matches plaintiff's exhibit 5 of their $310.12 added to the judgment figures. I didn't need an audit to do this. All I needed was the record. So all I needed was the record. Another one. Okay. So, what to say? Here's the standard. A fake audit tells you about documents no one can produce. A real analysis is built entirely from documents the other side already produced. Source discipline. Every number analyzed comes from the servicer's own records, its filed exhibits, its account histories, its statements mailed to the borrower. Nothing rests on hidden bonds or secret policies, so nothing can be waved away. Penny level reconciliation, down to the penny. And no, they are not anticipating, especially with pro se litigants, to be putting every dollar, every cent, every penny under the microscope. They are not expecting it. The records are reconciled against each other, line by line. When a servicer's internal ledgers, its consumer-facing statement, and its court filing state 3 different totals for the same charge category over the same period, that is not a theory. It is an exhibit. Admissibility first. Every finding is framed for the rules of evidence, business records foundations, summary evidence rules, expert opinion standards, so it survives contact with a courtroom instead of dissolving there. Procedure is a tool, not an enemy. Court rules on defaults, evidence, and trial management, and federal servicing law that obligates servicers to answer documented error notices on statutory deadlines. Do more work than any theory. The homeowner's right under those rules exists whether or not a lawsuit is pending. Honest scope. Real analysis will tell a homeowner what it cannot do. It does not promises a free house. It identifies which amounts are generally disputed, which defenses the law recognizes, and where licensed counsel is required, because in litigation, strategy and filings belong with a licensed attorney and a homeowner's estate. Because we 100% open and honest. These claims are not going to survive, but these claims here will survive. I know you want to go with all these claims, but check out the case law and the procedural posture and how the courts view these claims of the past. Now check out these claims and see the relief granted under these claims. It is my advice that we should go with these claims and not those claims. And if you want me to file something for you that's more aligned with your belief system, I think you misunderstood what we do over here. There's no amount of money that you can ever pay me to have me file or pursue any claims in which the courts have universally rejected. Sorry. Red flags, a homeowner's checklist. Pay attention. It's the red flags, these auditors. And here's another thing about these audits. These audits, they are not actually, they're not helping you along the way. If they're providing you with all these things that you can do in course of actions, wouldn't they be helping you along the way? I mean, bare minimum, wouldn't they show up to court for you? No, I don't want to hear it. Everybody that's had an audit, that had a foreclosure case that I know, no goddamn expert witness showed up for them. Because the homeowner bears those costs, and you got to submit it to the court. Your proposed expert witness. You got to disclose that information to the other side. The other side gets to grill them, and the judge is going to do their checks and make their findings in open court that this person qualifies as an expert witness. You can't blindside them with it. They got to get sufficient time to prepare for this expert witness. No side can blindside the other in court. An upfront fee for foreclosure help before any result. Federal law prohibits it for mortgage relief services. Promises built on documents you can never see. Bonds, trusts, insurance policies, and registries. You are the creditor. Straw man. Accepted for value. Secured party. Fealty bond. Administrative remedy. All red flags. Administrative remedy in a mortgage case, red flag. Red flag. Because in these spaces, the minuscule, minor one-off is being promoted to the masses. Where substantive law cases and arguments where the courts allow is universal to all of us. Policy or registry numbers that cannot be verified anywhere the document tells you to look. Red flag. Instructions to file UCC financing statement, serve judges sureties, or notice insurance syndicates. Red flag. A guarantee. No honest professional guarantees a foreclosure outcome. And even with the Low Depot, the Florida case, I told her there's no 100% guarantees in court. Got a text message. Regardless of the outcome of this case, are you still going to help us if we got to go on appeal? I said, absolutely. Absolutely. That comes with it. All the way through. Because it's one venue where a lot of the ace in the holes that I really don't talk about online, there's one venue where the court actually entertains it. And that is bankruptcy. Like a rattlesnake. You know how they sit in the cut and wait for their prey? Go ahead and file that proof of claim in the bankruptcy. Go ahead and file that proof of claim. Go ahead. I'm waiting on it. File that proof of claim. File that proof of claim. Pressure to act before you could show the document to a licensed attorney in your state. This guide is educational material prepared by the Supreme Elite Team Litigation Department for general audience. It's not legal advice or creates no attorney-client relationship. Homeowners facing foreclosure consult with a licensed attorney in their state. Legal aid programs serve homeowners who cannot afford counsel. Because when you are acting and dealing like a professional, you are required to make those disclosures. It is ethical to make those disclosures. I know by saying consult with a licensed attorney, I know I'm really not supposed to be putting that there if I'm trying to get services. I know I'm not supposed to be putting that there, but you always have to abide by the ethics. Luckily for her, all I got to do is, yo, check this out and hit send. And there's going to be professional, real attorneys, decorated careers, eyes on it. But it's not the case for everyone. Now, here is the actual audit, which is personal information is redacted for obvious reasons to protect the identity. MLT Integrity Audits, LLC. MLT Integrity Audits, LLC. Forensic Audit Summary Report. This forensic audit reveals systematic securitization fraud. There you go, right there. Red flag. Securitization is not a fraud. Securitization is highly regulated and perfectly legal. Securitization is the reason why many people who cannot afford to purchase that $50,000 cash, vehicle cash, even though if you purchase it cash, the sticker price will be different. But when you get financing, that $27,000 shoots up to $50,000. But that's not the part of the conversation. Securitization allows many of Americans who otherwise couldn't purchase or don't want to purchase the property outright with their own assets and resources to allow them to get the property now and pay back over time. Believe it or not, millions of Americans are dependent and businesses dependent on securitization. This is how you can qualify for a business loan, business lines of credit, credit card, able to finance the vehicle, able to get a mortgage to move your family in the home. Believe it or not, we are all dependent on securitization because I don't believe anyone that's listening is a multi-millionaire, wealthy beyond their means that's listening, including myself. So we're going to keep it honest. You are more dependent on securitization than your distaste for it. Because everyone that has something to say about it, they always got a credit card application they filled out. There's always a application for the vehicle they filled out, and there's always an application to purchase the home that they filled out. You want to know what allowed you to even fill out that application and get approved with a credit score of 620? Securitization. Why aren't you going through your secret account to purchase the home? Put a claim in for the $800,000 from your trust fund account to purchase the home. I thought there's an account in our name that everyone can draw down to pay their debts. I thought you were the creditor. Well, if you are a creditor and you step into my world and I give you this application, that doesn't automatically make you the creditor in my world. In my world, you're the debtor. You want this house? Cool. You meet the minimum requirements? Cool. Bring this amount to close? Cool. You're going to pay back the loan that I secured from you on the secondary market, and you're going to pay back interest so I can make a spread. I can benefit from the spread. I can benefit from the yield. I can benefit from the operations of doing business, and I can mitigate my costs and risk by selling this agreement we have to them. So when you're paying back the principal and interest, that portion is going to them. The fees, the escrows and all that, the advances, the insurance premiums, I'm going to use your monthly payments to pay that. And I'm going to collect my servicing fee off the top of your monthly mortgage payments. But I don't have just you. I got 40,000 other people that I'm servicing this pool from that is making the same or close around the monthly payments a month. I'm living good over here as a lender. I'm good. I got 40,000 of you. See, that's how they look at it. That's how they look at it. You cannot defeat these people or even put a dent in their right to collect or defend against your claims by looking at a mortgage transaction solely, and I don't want to ruffle any feathers by saying this, but by solely from a consumer standpoint. It is impossible to understand what's really going on if you're only looking at it through TILA, RESPA. Forensic audits of systemic frauds involving your property at redacted location, Atlanta, Georgia. Your mortgage has been immediately securitized into a Ginnie Mae pool with the master bond identifier QSIP number traded globally as a mortgage-backed security, used as collateral for multiple derivative instruments and insured through Lloyd's Syndicate 3333 for $250 million. There's none of that exists. I've looked it up. It doesn't exist. And a QSIP number means nothing. Y'all, please listen to me. A QSIP number, even if you have a legit one, all it does is identify a security. It's a security identifier. No security travels through the secondary market, the international market, the S&P, the 500, the CDOs, the CDS, none of that. Euroclear, Bloomberg, none of that. My friend is a Series 7 securities broker. You don't think I can find any security? Who has a security clearance? All I need is the loan number. What's the loan number on the contract? And find it. Having the information means nothing. You got to stop thinking that your mortgage. I don't even think I should be saying it because I might be saying too much. Let's get to the audit. The foreclosure filed against you in Fulton County Superior Court case blank is legally invalid because Lakeview Loan Services does not hold your original promissory note as it was destroyed during the securitization process. You don't know that. That's not even how it works if it's insured with Ginnie Mae. The original note has to be transferred to the custodian. What are you talking about? Lie. This is a lie. That's not even how it works. They don't destroy the original note. There's a whole set of process behind the scenes that they have to do. And the original note, you know what? I'm so tired of these. I'm so tired of these so-called audit people that's getting people out of their homes. Right here. This is part of the exhibit. These are the requirements. Right here. You're looking at it on YouTube. The corrective documents must be filed with the original note. If initial certification of the pool, the issuer must obtain the borrower's original signature on a copy of the pooled note, or the pool may not be certified. Neither a lost note instrument or bond or a lost note affidavit may substitute for a missing pool note at the time of initial certification. Stop. You got the right one on the wrong day. You can say whatever you want about me, but when it comes to this secondary market, the corporate finance and the mortgage, I really don't want to. Yeah, trust me. That's a lie. That's that 2008, 2009 destroyed note stuff. Your mortgage loan originated in July 2019 through Movement Mortgage Loan Number for the property located. 30-year fixed 3.7% interest with an interest payment of $1,400. FHA case number and merge number. Those FHA, they're lying. That, oh my gosh, it doesn't work like that. Within 48 to 72 hours of your loan closing, Movement Mortgage sold your promissory note to Ginnie Mae to multi-class remake pool. Your loan was pulled into Ginnie Mae loan number, which was issued in August 2019 with the approximately $248 million. Your specific loan contributes approximately $144,300 in original principal to this pool. You have no evidence of that. And there is no exhibits I received with this. You have no evidence of that. That is not how they do that. All they did was take the 248 and then her portion of her monthly payments to the loan. That's not even how they calculate them. They calculate them from a totally different way. It's not even based on your mortgage payments. That's why all these MBS mortgage-backed securities people online, they have no clue on how it's calculated. They have no clue on how it works. They still think their loan and their mortgage was actually pulled. Your mortgage is not actually pulled and sold. Don't worry. Well, I'll be on the phone with the Fannie Mae senior supervisor analyst tomorrow. I'll be on the phone with him tomorrow. I will be on the phone with him tomorrow. The CUSIP can be verified through multiple independent sources, including the Ginnie Mae disclosure database at GuineaMae.gov by searching pool number, Bloomberg terminal ticket. It's blank, and global book entry ledger showing Seed Co as the nominee holder of the CUSIP. Lie. Looked it up, didn't say none of that there. Lie. This is that old 2007. I can see it right here. It's that 2007, 2008 mortgage crisis arguments. And SEC Edgar filings for Lakeview Loan Services showing your loan asset number in the ABS-EE disclosure. Actually, no. If it's a loan, a mortgage, what this is, it would be a mortgage-backed security, not a asset-backed security. This own report is contradicting itself. The FAH insurance on your shit. The FHA insurance on your loan with case number. How can you have a case number in a Georgia court if Georgia is a non-judicial state? Meaning in a non-judicial state, they don't have to file a complaint against you to foreclose. How do you have a Georgia case number if Georgia is a non-judicial state? Somebody please tell me. He said, I did with my birth certificate. 100K, you gotta be joking. Credit repair specialist removing negative items from a credit report is okay. Credit repair specialists cannot charge upfront until the items have already been removed. Federal law was just passed on that, I think last year, 2 years ago. Yeah. Yeah. A credit repair specialist cannot charge you upfront. Federal law bans it. There actually have to be movement, a reduction in your, negative items before they can charge. So if anybody's talking about they can clean your credit and repair your credit for you, they're lying. Federal law prevents it. It's not for your benefit as the homeowner, but rather serves as a guarantee for the securitization vehicle to make your loan more attractive to Wall Street investors. Anytime you hear the general term Wall Street investors, or they sold it to Wall Street investors, anytime you hear that general term, that is that sovereign citizen, that scam, like, I don't understand what's really going on, so I need a filler word to accommodate for my lack of understanding. So what's the normal word we hear everybody use? Wall Street investors. This insurance guarantee is what allowed your loan to be bundled into the Guinea Maid pool and sold at a low-risk investment grade security to institutional investors worldwide. First, it was Wall Street investors. Now it's institutional investors worldwide. And no, that's not what it did. An insurance guarantee, an FHA insurance, is an insurance that protects the lender in case of a default. Your loan being accepted into a pool, that's a totally different process, which is universal. You know what the process is? The same process, the same documents, the same evidence they wanted you to provide with your application, your W-2s, how many assets that you have, things like that. Movement, mortgage, and origination fraud. These are that fraud word that is always attracted to distressed homeowners, because they think that you hear the word fraud, it means that, well, damn, I'm going through all this trouble, stress, and I ain't supposed to be paying you anyway. That's what goes through their mind when they hear the word fraud. Moving mortgages registered as okay, that's general information. The company functions as originator and aggregator whose business model depends on immediately settle loans into the secondary market rather than holding them in portfolio. You're not saying anything that's so groundbreaking. That's standard operating procedures. Moving mortgage is not a traditional lender, but rather a loan production factory. There you go. See that right there? That creates mortgages specifically designed for immediate securitization, such as hundreds and thousands of other mortgage brokers. You're not saying nothing that can help her here. But see how it's under the heading fraud? So they think a normal regulated practice, which is nothing illegal but what they're doing, they got the borrowers to think it's fraud. This is why many people view securitization as fraud, not knowing that it's 100% legal. Movement Mortgage channels a significant portion of its profits through a non-profit entity called Movement Foundation, Inc., and is registered as a 501(c) tax exempt. This is lies. This is all lies. So this whole audit report is inconsistent and lies. All this here is inconsistencies and lies. There is nothing. Attorneys, bonds, this is a lie. Attorneys, they don't even have bond. Like this is a sovereign citizen scam. She brought a scam. All this is a scam. None of what it's here it's a scam. Judicial bonds, the judge's oath number. They're making up lies. Zurich, JD, lies. None of this is real. I did a whole check on this. None of this is. The only thing that is legit is the same things that she got in her QWR. Remake means nothing. Lloyd's Syndicate 333 Apocalypse Policy. A master reinsurance treaty. This is crazy. Global mortgage back. This is crazy. Oh, this policy is $250 million. You can make a claim against it. This is absurd. Wasting all this time. Chain of title fraud. This is wasting time. And this is what they have you do. The blank law firm and title insurance fraud. They have you waste so much valuable time. What you could do with this information, this is what I want to get to. The most powerful section you could take from this is to file a notice of securities discrepancy with the SEC whistleblower office using form tips. You are a mortgage borrower. You're not an investor, a securities broker. You have no standing to file this. I told you, this is taken straight from the sovereign citizen playbook, because in these spaces, many sovereign citizens thinks that they could wear 5,000 hats at one time. First, let me say, these are the hats that they think they can wear. These are the hats. They're the executrix of the estate. And they're the beneficiary of the estate. Then they're the grantor of the estate. Then they're the investor. They're the beneficial owner of the securities. Then they're the living, breathing flesh and man. Then they're God of the land. Then they have nobody can tell them what to do because they have this exotic third-party treaty diplomat status. And the list goes on and on and on. But every single one of them, when you look at their everyday lives, none of them lives like the statuses that they claim. They should be trillionaires, all these hats that they wear. They're the creditor. They provided the money. But you're being sued at the same time. It's just like when Tory tried to say, oh, I still got the vehicle because I put it in a trust. Sovereign citizen tactic. But I'm suing them because they didn't loan me nothing. Are they coming after you for the vehicle? No. Huh. So they're not coming after you. You have the vehicle. But you want to sue them just to say they didn't loan you nothing. And is that where this space has come to? Because that's why. And then when I start digging more, I said, well, do you have the, so since they're not coming after you on the vehicle, do you have the title? Well, I have my title. No. It's called a certificate of title. And for my allodial title people, that only deals with the federal government. So trying to discredit someone, and what it really is, you're upset because you don't have a certificate of title with your processes. So you want, oh, you don't have the allodial title. That doesn't apply unless it's the federal government. It is an ancient, old title. Only applies to the federal government. Allodial title to the land. Federal government. You got to update your Black's Law Dictionary. So I said, hey, so your title. I said, so was the lien released from the DMV records by the lender, the auto company? Was the lien released? And then it was about 5-10 minutes to gaslighting on the question. Like, if you know, I mean, it's a simple answer. So after 10 minutes of gaslighting and moving the goalposts, she finally said, no, the lien wasn't released. So when she said the lien was not released, now the situation is clear. You're being sued. And you think that, in which many sovereign citizens believe, and this is the hallmark of them being so interested in the trust. They believe that if you put an asset in a trust, it stops the lender from collecting. They believe that they own the asset just because they put it in the trust. But they will ignore that the security interest in favor of the lender is still attached. See, these are these impulsive things that people just do. But when you sit back and ask them, they're so left dumbfounded, then you can see the gaslighting and moving the goalposts about to start because they haven't even thought that far. You point out the discrepancy between the SEC filings, which shows your loan as current and active, and the Fulton County Superior Court filing will represent your loan as being in default subject to foreclosure. This is a lie. There is no SEC filing that shows your loan as current and active. And number two, if you were in default and subject to a foreclosure, you're in Georgia. Georgia, once again, is a non-judicial state. They don't need to commence foreclosure action in court in order to take your home. They can give you default and notice of trustee sale. And that's all they need to take your house. Then under SEC rule, once again, when a securities discrepancy is reported, right here, number 47, the servicer is required to repurchase the security from the pool within 5 business days. That's a lie, because I just went over it yesterday. It's not a securities discrepancy. That's only in the event of default or certain circumstances take place. Then they have to repurchase. Has nothing to do with the securities being discrepancy. Actually, this stage has nothing to do with the borrower. And this is one of the hallmarks of sovereign citizens. They always want to assert themselves in positions and functions of the system that has nothing to do with them. Prime example, the remake. Oh, you transferred the loan late. That has nothing to do with you. You did not sign the pooling and servicing agreement as the investor. Only the investors can void a transfer into the pool. This is why the courts view those claims as technical and probably only most likely at most voidable instead of void, because you have no authority to reject a loan in which you are responsible for paying back into a pool. I know they like to give us these exalted statuses, and you could, these spaces, sovereign citizens, just like the army, you could be whatever you want to be in these spaces. Whatever hat you want to wear, you could just automatically wear that. Hell, you could start speaking in a new language if you want to. Now, all of a sudden, the United States this is all one big Morocco land. You're not in the United States of America. You're in Morocco. Well, what about the country Morocco that's on the map right there? That's not the real Morocco. Oh, okay. I get it. Simultaneously, you should serve a notice of claim against bond and affidavit of default on all 3 foreclosure attorneys referencing their specific professional liability bond and policy number. And they may have gotten this person to file things that don't even exist based on this right here, this trash of an audit. And I'm not gonna lie, it looks so sloppily put together. As soon as I seen the audit, I already knew, got caught in the scam. But it's so disheartening because when borrowers get it, they feel so empowered by it. And then instead of recognizing the reality, many borrowers would get mad at me because the way I'm delivering it. And it's not really the fact that I'm delivering it like this. It's because whatever in their mind that established that hope has been popped. See, many people just want reassurance in these spaces. They don't really want the harsh realities and the truth in these spaces. They want reassurance in these spaces. So then it goes down. You must file a notice of claim against the bond directly with Western Surety Company, referencing the judge, fealty bond. Do you see now you go judge's bond, and none of this has anything to do with default or challenging the foreclosure. None of it. Absolutely none of it. You should demand production of the original wet ink promissory note. File a complaint for securitization fraud. The CFPB only deals with consumer-facing transactions, not securitization, especially since you're not a party to it. The CFPB has nothing to do with securitization. Send a notice, serve a notice directly, and file a UCC-1 finance statement naming yourself as a secured party and Lakeview Loan Service as the debtor, which has been constituted as fraud if she was to do it. Because the debtor has to voluntarily sign it. It has to be a legit security agreement signed. Because herself, she would have to prove that Lakeview got into a financing with her and Lakeview pledged their assets to her in exchange for a loan. Does that even comport with economic reality? But this is sovereign citizens. They always think that you could take forms for legitimate purposes and use them for illegitimate purposes just because the forms fit the narrative. Prepare demand to dismiss foreclosure case. A whole bunch of trash. So that ends that. Now, let's get to let's get to a real, I don't know what happened here. I don't know why it's going. All right, let's get to a real case. So this is dealing with the Loan Depot. This is what an exhibit looks like. Plaintiff's own filing offered under 90.80318 Florida statute. The certification states as September 5th, 2024, the original note was located at 1245 28th Street, St. Petersburg, Florida. The office of plaintiff's attorney. So those exhibits I went over yesterday, this is kind of explaining why these exhibits are here. And that possession was verified by Tara LaVirtue, an original document processor employed by plaintiff's attorneys rather than by plaintiff. It does not state when plaintiff acquired the note, from whom the note was received, whether the note was released from a Guinea Maid document custodian, and under what release document, or in what capacity plaintiff holds it. You see how just that makes just more legal sense? Nah, man, the new culture, what you talk about, it don't fit the online narrative, man. Nah, it don't fit the narrative for me. I'm having a hard time following because it don't fit. I need something quick and fast that I can do. Quick, fast. Well, you know what? Something you can do quick and fast. Pay your monthly payments on time. But when you decide not to pay, then you can't dictate the quick and fast outcome. When you stop paying, you lost some of your power when you stop paying. So let's stop. And the reality is, many people stop paying in hopes of finding some defects in their complaints. That's one of the catch-22s with people winning credit card cases. It gives them the mindset that they continue to get credit cards and not pay. But when they run into an original creditor in a situation where they just not going for it, now they're stuck in their credit reports trashed. The note attached to the certification bears a blank endorsement without recourse, executed on behalf of plaintiff by an investor delivery manager. Exhibits D, offered as plaintiff's own records and as records produced in discovery. Defendant has requested and continued to request the forms, schedule pooled mortgage, request for release of documents, together with the identity of the document custodian and the date and reason for any release of the original note. So much for the note being destroyed. Exhibit K, plaintiff's own business records offered against plaintiff. Defendants do not concede that this document satisfied the predicate of 90.803.6 Florida statute for plaintiff's own affirmative use and reserves all objections to plaintiff's proof of the amount due, including objections to any data originated with a prior servicer or subservicer that plaintiff's witness cannot competently sponsor. I don't know why it's like this. Last one. Plaintiff's own filing of June 4th, 2026 offered under 9803 Florida statute identifies the investor type as GNMA and the investor number as G13, identifies the account as a first mortgage FHA residential loan, and states the components of the $422,516.86 payoff plaintiff demands. Its 5-page account history categorizes the corporate advances and that plaintiff's customer statements leaves undescribed. So when we take, let me see if I can go. I don't know why. Oh yeah, that's all pretty much when it shows. So when we take their records, these are their own records that they filed in court as exhibits. This is what they filed it in court as exhibits, right? So we take those records and then we analyze those records. Then you understand why they had to continue this for the third trial. Want to know why? Because now it's becoming a, let's just say, they're having a hard time proving the actual balance, which is one of the prerequisite evidence of them collecting. This is why a person could be already in judicial default, summary judgment at the evidentiary trial, and still having a hard time.
I'm beginning to agree with the defense that there's some confusion.
Now, has this experience so far been better than the one?
I'm beginning to agree with the defense that there's some confusion.
Now, has this experience so far? We want to say that again.
I'm beginning to agree with the defense.
I'm beginning to agree with the defense that there's some confusion. Now, ask yourself a question. We've been saying the same thing. We've been saying the same thing for hours. I think it's right. Two different things, how the judge court's going to view it. We've been saying the same thing for a couple hours across multiple. So we're going to go over the first 16 minutes. Let me see, 15 and some change. So you now can kind of crystallize what I've been talking about.
I'm beginning to agree with the defense that there's some confusion.
Now, has this experience so far been better than the ones that you had from the past with these gurus?
Yes, like you don't even understand. It's like another world. Because like I said, the fact that we even sit here and hash out like what went down, what the game plan is, or afterwards, like talk about, okay, this is what could have been done, this is what could have done, we could have done better, or this is where it could go, I've never had that with someone. No, they always just throw paperwork at me, like just figure it out, just read it, and that's it. And then, like you said, because then when it comes to court, it's not always going to go by that little scripture or by those claims that you're bringing up. It could go either way. Just like how we started asking them details about their claims, they're going to start asking us details about our claims. And the thing is, when these gurus just throw you a document, you don't know the details about it.
There you go. There you go.
You're rocking with the best.
Oh.
When people see helping her stay here, real people, real cases, real preparation, real results.
You're rocking with the best.
Also, I had a chance to go over the figures with the witness.
Yes, Your Honor, and she did testify correctly as to the judgment figures.
Oh, you did you? You did you? Okay.
The supplemental schedule that was filed with the court on June 4th shows the amount due and owing. I did state, Your Honor, that it's inclusive of the attorney fees and cost affidavits that were filed with the court that gets to the total of $432,694.62.
Oh, it does do it. Oh, you sure it does? Okay. So that's the conclusion you came up with? Okay. So that's the conclusion you came up with, right? So if you came up with that conclusion, how do you explain 105 entries after the complaint was filed that raised the principal balance due another 20,000? And all these, you had 13 entries before the complaint was filed, but after the complaint was filed, you had $18,343.90, 20,680. Oh no, this is my audit. This is how I audit. This is my personal audit. So then you have the following 9 appear on the account history. They appear on the account history and don't appear anywhere on the customer statement. So this $989, it wasn't part of the customer statement when you said to them. There go another $989 unexplained. And then you have plaintiff's judgment worksheet claims a smaller advance balance than its own ledgers. If the difference represents charges plaintiffs determined were not recoverable from borrowers, plaintiff has not identified which charges those are, on what basis the remaining $18,350.40 is recoverable under the note, the mortgage, or applicable Department of Housing and Urban Development requirements, which is unaccounted for $1,718.09. It's still unaccounted for. It's still unaccounted for. Or a Loan Depot, you're messing with a numbers guy. I'm a numbers guy. And now you got 8 charges categorized on plaintiff's account history as attorney corporate advances, totaling $3,960.90. But they're carried inside the actual corporate advance. But you're suing for separate attorney advances, attorney fees for this right here. Right? But then 7 of the 8 post-date the filing of this action. Plaintiff separately seeks an award for attorney's fees in paragraph 11 and in the prayer relief of this complaint. And then you got late charges that were 12 to 16 months after they were due. 12 to 16 months? I thought it was only supposed to be charged by the period, the late period. The late period. That's on the note, only for that period. So you added $310 more. Oh, come on. Yeah, we can get to it. Or we can get to it. Or we ain't playing. So that jumps up to $422,516.86 with $18,350.40, which is $1,700 of that is unexplained for. You got $310 that you charged that took place 12 to 16 months after the due date. And then you got all these unaccounted for fees and these inaccurate amounts. So what were you saying again, lawyer?
Okay, just because we're on Zoom and there's confusion because we're putting numbers around, can you screenshot your judgment and have the witness go through the figures?
Yes. Give me 1 second.
And then are the able to see the screen?
We're looking now.
Yeah.
Okay.
Okay.
Attorney's fee,
So-
16,000.
If the witness can go through,
And in court, this is what they're going to do. They're not going to do anything more or anything less. This is what they're all going to do. Remember, y'all, I'm on the phone here. They're actually in the hearing. I'm on the phone. I'm here with them. This ain't just helping someone with documents and filing motions. This is being in court with them. It's a difference between just filing motions and documents. This is actually in court.
based on your review of the records that are maintained
In the ordinary course of business. Yeah, it's the old cliche word they use.
in the ordinary course of business, and explain all these numbers and how they're arrived at, the defense is questioning.
Explain all the numbers and how you got to them. Not just reading them from a screen. How did you get to these numbers? Because I know how you got to those numbers, but you have to establish it. Because if you really explain how you got to the numbers, like I know how you got to them, you'll be exposing the corporate finance side.
Okay, so we have a principal amount of $316,690.
Okay, how did you get to it? Is she either going to explain how she got to it, or she's going to move on to the next item?
47 cents.
That was left on the mortgage, correct? That was the outstanding balance on the mortgage?
Correct.
All right. That was
Interest.
time of default?
Yes.
All right.
You see how the judge is filling in the little blanks to make sure she gets the actual proper words on the proper words. You know how the Dana, but she was leaving certain stuff out. But you know how the judge keep filling in the blanks for? Golly, judge.
Which, Your Honor, the final judgment just show the interest dating back to April 1, and the witnesses testified to the default date of May 1, 2023, just so there's clarity on that.
Okay.
That made absolutely no sense. That made absolutely no sense.
Run that by me again.
Exactly. Because it didn't make sense to me. What the hell is she talking about?
So it's showing the interest on the note and mortgage from April 1, because we're entitled to interest 30 days prior. The default date is May 1, 2023. I just wanted to make that clear.
So you're entitled to interest 30 days from the default date, right? So you're entitled to interest 30 days from the default date. Okay. You're entitled to interest 30 days from the default date. I got you. Explain this. Explain the late charges. Explain all these late charges. Explain them. The $310 now. You've been sent the default date. So that 30 days, I give you that right here. Explain all these. These are after the 30 days of the default date. Do you know how many times I went back and watched and analyzed this video and created more arguments and exhibits from what you see on this screen right here and from out of her own mouths? Do you know how many times I created that report basically from the record here, what's been filed in this hearing? I didn't need a securitization audit. I didn't need no social media gatherings on how to get, nope, straight from the record, straight from scratch. This is why with me, no one case is ever going to look the same. Every case is going to be built on its own records and its own foundation.
In this proposed final judgment.
All right. And the interest rate, the interest goes into today, June 11th. So that's $61,956.15 in interest that's outstanding. All right, go ahead, counsel, if you want to go through the numbers and just kind of have your witness explain them as you go along. What's the pro?
What's the difference between explaining the numbers and just reciting the numbers from a screen? Because I even got case law on that.
Yes, that's. Can you explain that? Go ahead. Sorry.
Yeah,
That was me in the background.
it's from mortgage insurance.
Mortgage, explain it. Because they got property insurance, damage insurance, with insurance. Where was the proceeds at? How much the proceeds you get? Because I already know it's the insurance that protects the lender in case of default. How much did you get? Explain it. It's for mortgage insurance. No, explain the mortgage insurance.
Okay. Does that mean that the lender?
See, why you keep saying, is that what that means? You see how the judge filling in the blanks for them? But we didn't panic, because there's no room for panic in these situations. There is no, when you're here, see, it's different when you got paperwork online and you just filing motions back and forth. When you're in court, it's a totally different ball game from the motion stage. So there's no room to panic right here.
Had to pay the insurance?
Yes, ma'am.
All right. Is that what we're referring to as corporate advances, or is that something else? The defense mentioned something about corporate advances, which generally my understanding is that would be more where you're paying for insurances or taxes.
Judge, you keep answering the questions for them. The corporate advances is a variety of charges that they slid in there, unexplained numbers under the heading of corporate advances. We wanted them to explain the corporate advances itemization by itemization, not you give your opinion on what it is, Your Honor. Golly.
Yes, so as you can see, Your Honor, then the entry, title search and expense.
No, what do you mean? Can you see the next entry? See that? You see how they just trying to skip? No, go back there. Oh, boy, I was hot on the fire. I said, oh, they, whoa, wait.
Are the costs that the firm expended for this case, but then you go into flood insurance disbursements, the tax disbursements.
Let me say, don't let it get by that. I said, get back to the corporate advance. As I was telling her, don't let it get by that, because he's trying to move on. And I know she was trying to move on. Bring your ass back over here.
Hazard insurance disbursements, those all cumulatively are the corporate advances and escrow.
No, the fuck they're not. Because the part of the corporate advances has fees that advances that you had to make that per your servicing agreement, you charge back to the borrower, which you did not disclose that any advances made, specific advances, not vague terminology on the note, advances made. You did not explain that.
Advances for the subject loan, and so the proposed final judgment breaks down these line items.
Okay, and just, I don't know if the defense are still with us.
Yes, I'm here, and I want to add
there you are.
that.
Okay, so
and what she's about to say, I texted her. I said, hit him here. Maybe we probably had about 75 texts during that hearing, because I can't say nothing, but I'm texting. This is what she about to spit from my text.
In your exhibit, because I see conflict already. In your exhibit 5 of the witnesses and exhibit list that you guys filed recently, the corporate advance is $16,955.90.
I told it, get back to the corporate advances. This is going to save your fucking house today. Get back there. Take that script, throw it on the other side of the room. We stand right here. We had a whole script, abandon the script. Go right here. Right here. We going right here. I found a soft spot right there.
I did the math already. These numbers are not matching up. So what would be, if you're saying that that's the attorney fee, so what is that $16,955.90?
Yep. Because you just tried to slide the attorney fees inside the corporate advances, but then you said you're suing for attorney's fees, which is the corporate advances, but you got the other fees outside the attorney fees and the corporate advances. No. She's with someone that is a numbers guy. All I do is numbers. Absolutely not. You talking to a person that knows how to cook books legally. You think I'm not going to know when you're trying to cook the books?
If you already had your attorney fees over here on this document that you're showing me.
Gotcha, bitch.
I'm not sure which part of the record.
Document that you're showing me.
Gotcha, bitch.
I'm not sure which part of the record she's.
It's in your exhibit list.
you know what page of the exhibit list?
The last one, page 33. Exhibit 5.
You hear me in the background? Exhibit 5.
5, which is the judgment figures.
Crickets.
And then
that's me instructions again.
And while we're adding to that too, another thing that I wanted to mention is that all the other documents have the header Loan Depot, but this one doesn't. And also the total amount due is redacted. Why?
Clearly, the total amount due, if y'all look, okay, YouTube, look at the first redacted line at the top. Those words next to it says amount due, total amount due, and it's redacted. Why are you redacting the total amounts due?
I believe.
Okay, and that big blocks right there, TikTok, y'all can't see, but you can see that big block, redacted block, not the long one at the bottom, the one in the middle, right? That says at the top, investor GNMA, investor type GNMA, and investor number G13. This was redacted. When they filed the updated versions, they forgot to redact it. And they left it out. They forgot to redact it. They didn't want us to see that. So when they filed the second one, where it was unredacted, which I believe that they inadvertently did it, now it opens the door to the other side because you filed it on the record. I couldn't just bring it up. They filed it and made it part of the record. Now we can talk about everything that's on the record. Fell right in our lap.
Earlier, because I'm taking notes here, let me see, that the witness already testified to a specific amount that wasn't even the amount that's reflected on that exhibit.
Gotcha, bitch.
And then.
Gotcha. What is the hallmark? Inaccurate amounts due precludes summary judgment from the court and legal standard. Come on. And more crickets.
We need to do one thing at a time because we don't.
No. Don't slow down now, Judge. You wanted to answer all the questions for him last 5 minutes. Don't slow down now. Don't slow down now because the judge is starting to see it. She starts to see it. And look at the lawyer that's on the right-hand side. Look at her. Look at her. Just sitting there looking stupid. All of a sudden, she got a medical procedure on the same day as the July 11th trial. So she got to continue it for another 45 days. Y'all are at the home stretch. All you got to do is prove the amounts due and she loses her home. That's all you got to do.
Have the exhibit that you're referring to in front of me. So are we looking at the witness and exhibit list that was filed on 5/13? Counsel?
No, Your Honor, this is the supplemental exhibit 5 of the judgment figures that was filed on June 4th.
And that's what cooked them. That's what cooked them right there. You want to know why I cooked them? Because even those numbers are off. So if the first numbers haven't been reconciliated, you can't file new numbers because the old ones haven't even been reconciliated. So all you doing just adding more unexplained numbers on top. So anytime they want to file new numbers, those new numbers still not going to bring them to where they need to be. They are stuck.
Okay.
It was a supplement to update the judgment figures and the breakdown of those figures more succinctly. So it was filed as a supplemental exhibit on June 4th.
Right.
Okay.
So I'm not sure if she's reading off of this exhibit or the previously filed exhibit from 5/13.
So are you referring to the updated exhibit that was filed on June 4th?
I'm checking now.
And while she's checking, counsel, it's showing a payoff of 422,516.86.
Yeah, they did. They made it a new one over at
So how do we get the extra?
So hold on. Watch this. And the judge caught it. Hear the judge clearly.
10,000 on that.
So like they're really trying.
Extra,
hold on.
roughly 10,000.
Yeah, they did. They made it a new one over at
Hold on, y'all. Hold on.
It's showing a payoff of 422,516.86.
Yeah, they did. They made it a new one over at
So how do we get the extra roughly 10,000 on that?
So like they're really trying.
So right there. How did you get the extra 10,000 with the new numbers when you didn't fully explain the no numbers? So when you filed the first one May 13th, you had a set of numbers. When you filed the one June 4th, you added 10,000 more. Explain the extra 10,000.
I'll do the math over here.
This summary does not include the attorney's fees and costs that were expended.
What? Doesn't even make sense.
Okay, so we would take that payoff number and then add your affidavit of attorney fees and cost.
God damn, Judge, just tell them what they need to do. What do you mean, take it and add it to this? No, they got to add. What do you, God damn, Judge? I'm like, Lee.
Correct.
And you heard that unconfident, correct? Look at the silence.
I believe so.
Look at the silence.
Okay, I'm reviewing it. I just pulled it up. Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
Gotcha, bitch. Yep. As soon as they add the new numbers, she did the math. I'm doing the math. And you know what's so crazy? She had a different set of numbers from what I had. I was like, I got this. That's still off.
I'm tending to agree. I'm tending to agree. I'm tending to agree.
Facts. Numbers is off.
I'm tending
Not up.
Gotcha, bitch.
Saying that the 4,600. Okay, I'm reviewing it. I just pulled it up. Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
Gotcha, bitch.
I'm tending to agree. I'm tending to agree. I'm tending to agree.
And you know what's so crazy about it? Y'all, I don't know why they ain't record at all, but we grilled the shit out of their first witness. See, they didn't. The other witness ain't even come back for the second. She passed this matter. This is just the restart after she went over like 3 or 4 cases. She had to pass the matter the first time because what kicked it all off is by the time when they was going to admit these as exhibits, I was texting her, object, the numbers are off, object, because if she ain't read the text too late to after she already admitted it, because if she would have objected right there, this would have been the conversation before the judge ruled on its admission. See how this conversation going back and forth? So she wouldn't have ruled on the let it in yet because we objected. Now we getting over the numbers. The judge would have had to deny the entry, like, I got to file some new numbers to get it back, which would have damaged them. But she didn't read the text till like 2 minutes later. I was like, object. But I can't say nothing when I got to text it to her. So we went, she had those numbers. So we just broke those numbers down and said, no, it don't add up. It don't add up.
I'm tending to agree. I'm tending to agree. I'm tending to agree.
You're rocking with the best.
They studying the source now. Supreme Elite.
And remember, before this, the judge was doing the same thing in the first hour. Just letting it go, letting them, explaining it for them, explaining it. Oh, no, I think they met their standard. I'm like, God damn, Judge. I'm like, golly, Judge. Please get out the way. The judge was in our way until she couldn't. She started to see, and this is what I tell you when you're in default in court. The judge is going to have a little bias against you. If assistant counsel was a person, God, I'm like, God damn. Like, how many times are you, judge, be quiet. Let them do it. And she was like this for the first hour, but we had to stick through it. We couldn't get upset because she tell you the judge is helping. I said, I know, just don't stay in the moment. We don't have time. We got to just keep pushing These are the barriers. These are the nuances of court. These are the things that you deal when you're already in default. When you go to court, the judge and the courts are going to have a little specific bias, and they're going to lead towards the numbers. We have to fight and fight and fight and fight and get over the hill, and we got to get the job done. We can't complain about how unfair it is. I know it was, but in that moment, I wasn't worried about. I was just like, all right, damn, judge. Okay, come on, let's get back focused. Stay focused. Stay in the moment. I was texting her, stay in the moment. Don't get flustered. Take a deep breath. Don't get flustered. Stay in the moment. Stay right here in this moment, because this was going to help her further.
Okay, I'm reviewing it. I just pulled it up. Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
Gotcha, bitch.
I'm tending to agree. I'm tending to agree. I'm tending to agree.
You're rocking with the best.
They're studying the source now. Supreme Elite.
If you take your payoff amount, you had 4,000 and 10,000. It's going to be more than your 432.
You see how the judge is now shifting towards our side? You see what we had to go through in order to get the judge to start to see? He said he just left the sovereign citizens avenue. Freddie was over there battling them. But you see how it is kind of like when you're in default. See how what you got to fight through. Now that once you fight through, you make consistent and you stay within the law, because them is the inaccurate amounts due. You got to have the proper amounts due. So you notice how the judge is now like, hold on, I'm shifting over to their side now. I'm shifting over a little bit. I'm now just starting to agree with them. Meaning the first hour, she wasn't really trying to, she was on their side because she's like, hey, you're in default. They got the numbers. She was anticipated and expected to rule for them that day, but we kept hammering them.
Off amount, you had 4,000 and 10,000. It's going to be more than your 432.
Crickets.
And then, sorry, Judge, I know you mentioned one thing at a time, but again, that document does not have the Loan Depot header. The witness already testified that.
But at this point, the judge, in her mind, she already made her ruling. She wasn't going to make a ruling today. We're going to send it back. She's not going to make a ruling. Now, why didn't she just dismiss it? Because the realities of court, and I love this video so much because it moves beyond the just responding to motions and documents and this. This is in court. In court. It's not that cut and dry. This is in court proceeding.
All these documents came from Loan Depot.
Yeah, they work from Loan Depot.
And more crickets.
You mean the Exhibit 5 doesn't have a header on it?
Yes.
And the account history?
Yes, there's no way for me to guarantee that this came from Home Depot.
Like that header. The Loan Depot header.
Oh, I mean, and how can I verify that it's...
That doesn't have a Loan Depot header. In your honor, you knew exactly what she was talking about. This right here doesn't have a header.
First-hand knowledge.
Gotcha, bitch.
Okay, well, the heading is basically part of the, establishes the lawsuit.
That's not what we're talking about, your honor. God damn. God damn it, your honor. 2 seconds later, you're still trying to answer for him. Attention to detail. God damn it, your honor. Please, can they answer one thing?
The parties to the lawsuit. The exhibits wouldn't necessarily have that header on it. You'd have to look at where it indicates the name of the borrower, co-borrower, addresses, those type of things to determine, if it's correct.
No, it's not. Oh my gosh, your honor. And she answered the question because she thought we was talking about the lawsuit, the heading of the lawsuit. No, we're talking about their exhibits. Just shut up, your honor. Please. God damn it.
People, but counsel, I'm a little confused too now because these numbers don't add up. Counsel, I'm a little confused too now because these numbers don't add up.
Lamont is only one of maybe
handful of people, 5 people, that I have the utmost respect for what comes out of his mouth.
Huh? You said what?
You're rocking with the best.
What is the core elements of a claim? The accurate amount due. They are going to slide fees, advances, expenses into it in which they can't explain its origins. So when you try to supplement and file more on top of that, all these amounts, all these figures, I'm a numbers guy. One number is off, it messes up the whole balance sheet. And this is what they're experiencing. The problem for them is this is one of the prerequisite elements that they need until those numbers are established. Exactly. They need the numbers established. The problem, 100K, they can't establish the number because we have over 16,000 that's still unexplained for. So they just got to get this key. And he said, man, I'm about to go back and look at the paperwork. That the numbers are never going to add up when you're dealing with a securitization, third-party records, and then the fees and the agreements and the amounts that are being charged back to the borrowers based on their own servicing agreements and their own insurance agreements. This is why they can't explain it, because they are passing their stuff on to the borrower, but they're blurring the lines in the note by saying any amounts covered by the lender or the investor or the holder may be charged back. So they blur the lines there, but when they actually got to explain all the numbers in a securitization, it is impossible for them to have the 100% accurate numbers based on the use and forbearance of money. Because all the numbers they're adding in there, 98% of the numbers has nothing to do with the use and forbearance of money. Has nothing to do with it. This is the corporate finance side, what we're attacking here, because this is everything that has to do with their financing and their agreements and the shit that has nothing to do with us. But they try to slide it through the back door, and we caught them. And the judge caught them too. But I wish he would just be quiet.
I'm beginning to agree with the defense that there's some confusion. Lawsuit. The exhibits wouldn't necessarily have a header on lawsuit. The exhibits wouldn't necessarily those type of things to determine if it's the correct people. But counsel, I'm a little confused too now because these numbers don't add up. Counsel, I'm a little confused too now because these numbers don't add up.
Lamont is only one of maybe a handful of people, 5 people, that I have the utmost respect for what comes out of his mouth.
I'm beginning to agree with the defense that there's some confusion.
What? I do not understand.
And then the total amount
Busher,
due is
you able-
rejected.
Ms. Busher,
Now she's getting into full panic mode. And you would think she's about to break it down. All she's going to do is just read from the same screen.
you able to break down specifically for the escrow advance amount? That's the $24,753.98.
But the escrow advance amount is not going, she's not going to say what Loan Depot already admitted to in their public filings of what the escrow advance consists of. She's not going to say it. And I wanted to hit into that this hearing, but you got to understand, I can have my understanding of it. You can have your understanding, but when you're dealing with someone else, it's not about the understanding, it's the communication of it in court. So I knew she's not at that stage yet. So I got to build to her strengths, because one of her strengths is identifying things when they're not right fast. So I just got to keep her here. This is why I didn't have her really get into all that, because it's you got to look at the situational awareness.
Are you able to provide the breakdown of that?
Nope. Or the silence. More silence. Excuse me.
I got you to my ear, so whatever you want me to say, I can say it. I got you low too.
And guess what, y'all? There was 10 people that was on the Zoom right there that day. There was 10 people listening. Everybody was tuned in. They were like, oh shit. Everybody was tuned in. People started turning their cameras on. She was telling me, like, people started turning their cameras on and shit. I was like, oh shit.
I'm trying to get you close enough to hear it, but sometimes you get loud and nothing to hear it.
Does it have to?
So for the $24,870.65 payment into escrow.
You're just reading from a screen. No, explain the damn numbers. I know you can't. That's all they're going to do is just read from a screen. That's all they're going to do. No, break down the origins of those numbers, the foundation of those numbers, and where those numbers derive from. I know where they derive from. I know you don't want to talk about where they derive from. So they're going to say, oh, we got that for escrow, and we got this for here. You already did the same thing 2 other times during this scene. You're not doing nothing new. All she's doing is just still reading from the same screen. You're not saying nothing new.
Another $59,2263 went into escrow.
Is that a breakdown? You're just saying what went into it. Want to know why? Because they don't even know. Remember, she's the attorney for them. Danis Bush, she works for the attorney. The attorney don't even know. Yeah, they don't even know. This side of the fence. They don't even know. They don't know. I knew I held. They don't even know. Oh, shit. They don't even know the numbers they reading. They don't know the origins of the numbers they reading because the companies don't tell them everything.
Then we have the deduction of the POI payment, $9,759.72.
Okay, where did the PR come from? What does the PR mean? Where did it come from? Huh? Explain that breakdown. Where see, they don't know. They don't know.
Then the tax payment, $11,534.31.
Okay, so what consists of the tax payments? Did you have to cover those taxes on your own? Did you have to use an advance to cover those taxes? Did part of their monthly payments go towards those taxes? See, we're gonna explain all that. Because any part of the borrower's payments that went towards those taxes, those amounts at least got to be reconciled against the principal balance. And if you did that, then you're going to have a different number. So you're still at the same position. And I think at this part, this is what the judge is picking up on what we picked up. There's nothing that they can do at this point to change this situation. There's nothing here in this moment that they can do. And I think the judge already knew that as well.
You don't know though.
Then we have the flood insurance payment, $62.15.
But what flood though? Where was the flood damage at? How you get a flood payment and there ain't no damn flood?
And then we have the insurance payment of $42.50.35. That totals the escrow.
Did any of that even explain or break down where, why? How was it calculated? What was the source? Did they have to cover it? Did y'all hear anything? Want to know why? Because you never are. This is all black personal knowledge. She just reading from a screen. She has no clue. She has no clue. She wasn't there with the insurance contract. She has no clue where it came from. But this is what they do when they come with these little witnesses and these ones that's going to testify. They're going to read from a screen and they're just going to read off what's going on. They're not going to explain how the numbers was calculated, whether the numbers were reconciled. No, none of that. And that is evidence of lack of personal knowledge when they just read from a screen.
For $24,966. $24,966.10.
And I got a different number. My number is like $300 off. It just everybody had different numbers. I wish she would record it from the beginning, would set this all off when the court reporter blurted out, I got a different number. I swear to God, when she did it the first hour before they passed the matter, the court, I think was done the numbers. I was looking at the numbers. I'm like, I'm scratching my head. Like, hold on now. Something I'm saying right here. But I got to move fast. I got to move fast because I'm on the phone with her. She's in trial. It's her house that's on the line. So I gotta move fast. And the court reporter, I got a different number. Bell went off. Uh-oh. Throw the script away. Throw the script away. We stay right here on these numbers. We stay right here for the rest of the proceedings. And this what started it all. That court reporter, I got a different number. Yep, that's what started it all. I swear to God, that's what I don't know why she recorded. She came out, hold on, I got a different number. I said, uh-oh.
Did any of these fees come from any of my monthly mortgage payments?
Right there. I told her to ask that question. Did any of those fees come from the monthly mortgage payments? Because if they did, then they would have to be reconciled, meaning netted against the principal balance.
Come from any of my monthly mortgage payments? Or did you take out insurance into this?
Well, I believe the terms of...
God damn it, Your Honor, we didn't ask you. We asked her. We didn't ask you. Golly, Your Honor, get out the way. You know what we try to do. You know where we lining them up. Please get out of our way. Y'all see what we had to go through? Do y'all see? Y'all see what we had to go through? Y'all see this? All hearing the judge was doing this. All hearing, I'm like, oh my gosh, judge, please get out of the damn way.
The mortgage require that the borrowers maintain insurance on the properties and that you pay the taxes. And I believe your mortgage probably said that if you don't, that the lender can put what we call forced insurance. Basically, they buy the insurance to protect their property.
That's not what insurance we was talking about. We was talking about the premiums under the insurance contracts that you sign with the FHA or HUD of VA, where part of the borrower's monthly payments goes towards those premiums as related to the note as part of the priority of payments, Your Honor. I started telling you, take me off mute. We about to let them know I'm here. Your Honor, that's not what we're talking about. Please let us. God damn it. Oh, I was walking around this house so fresh, like, God damn it.
Which is generally more expensive than if you took it out, but it's only because you're in default that they have to take it out.
You see how she brought up that default? You notice how the judge said, because her job is to listen to both sides, not interject. Bruh, folks think it's easy until it's them. Both of y'all made the good points. No, they think it's so, just cut and dry. It's not cut and dry in court. We did everything under the rules of procedure. We attacked everything under the rules of procedure. We did not come with any frivolous claims. Every question we asked, every attack that we had, we under the rules of procedure. And the judge was still answering questions and interjecting. I've never seen a judge interject the way she did. Just kept interjecting. And I could see she was interjecting on her behalf, but you would think she's the pro se defendant. You would think Linden Club and their pro se. I seen her interject on behalf of pro se. These are professionals. She had to, yes, she was saving them. Want to know why she was saving them? Because she's in default. That's the only reason why. If she wasn't in default, her disposition probably would have been different. But she's in default. She's literally saving them. I counted almost 10 questions. I think it was like 8 or 9 questions that we posed to Loan Depot's attorney or Dana's Bush that the judge answered for them. The judge answered. I'm like, oh my God, you gotta be fucking kidding me. But I'm not telling her that. I'm telling her, chill, relax, stress is cool. Because she was getting flustered like the judge keeps. But I'm like, God damn it, you're right. But I can't let you know I'm mad too. Somebody got to be cool.
So that wouldn't be in your records because you didn't
Oh,
pay
what,
it. That's
putting
why
the
the bank had
insurance?
to pay it.
But that's not the question that we asked, Your Honor, and you're still answering the question for them. I'm telling you, in court, it becomes an uphill battle when you're in default. When you deal with people who their only experience of court is just filing motions, behind the scenes motions, ask them to actually show up to court or be on the phone when a client got court, if it's on Zoom, and see. I only think a select few people in these spaces could have done what we did in this hearing. Thinking on our feet, because the only way that you're going to be able to think on your feet if you understand the court rules of procedure. If you understand the court, staying in honor changes the game. Yeah. Yeah. But there's going to be a prejudice, and I knew this going in, that she was already in default. There's always a unbiased, it's just a biased prejudice against the defendant. What I didn't expect was her to start answering questions for them. That's what kind of threw me for a loop.
Is there any evidence of the insurance being paid in? That they took out the insurance.
I told her to ask that question. Okay, Your Honor, since you want to answer the question for him, then let's just pose the question based on your response. Is there any evidence that they actually took out the insurance? And more silence.
Okay.
There's no requirement.
And now you see how the judge passed the buck on him? See how the judge passed? You see how the judge passed? Okay, counselor, you can answer this time. I'm like, God damn, won't you answer? You answer everything else because you know you couldn't answer that question because you don't know. The same reason why you should have been answering the last 7 questions.
Okay.
There's no requirement to establish insurance being taken out, only that the payments have been expended, which is what the payment history that's been admitted as Plaintiff's Exhibit 4.
You see that weak ass answer? So there's no requirement to establish that insurance been paid out, but only that it's been expended. So what happens before you expend it? It had to be taken out. So you can show that it's been expended, but you can't talk about whether it's been taken out. You see that right there? You see that? There's no requirement. She didn't say under the court rules. She didn't say what rules that it didn't. But only thing that they could show is that they expended on it. They don't have to show that they actually took it out. That there's a pre-existing, I'm not saying the exposed actual contract, but some evidence that they was charged it. How do we know you was charged that? How do we know you're not just sliding that in there as a different fee, like an auxiliary fee, but you're charging it as insurance? How do we know you're not doing that?
Have been entered into evidence.
Oh, really?
I'm just trying to double check here on the attorney fees, Your Honor.
Right, because you just noticed you see your own trying to double dip because the attorney's fees are supposed to be the corporate advances, but you already have your stated attorney's fees. So explain the corporate advances. Because first, the judge, my understanding that attorney fees is the corporate advances. But we pointed out, no, you already got your attorney's fees over here. So explain the corporate advances. And now, judge, the lawyer, she can't explain it now. And the more silence. Go fix it again. Come on, more silence. I know.
And then I want to know, how did our monthly payments not go towards the monthly premiums?
I told her to ask that question too. You hear that question? You know where that question comes from? Right on the note, priority of payments. Part of the monthly payments is going towards the premiums. So he said, hey, yo, ask her, how didn't your mortgage payments go towards the premiums on that insurance that she's expended? Want to know why? Because I'm tied it into the reconciliation. Because if any dollar of ours went to that amount has to be reconciled against the principal balance. Oh, lining them right on up on the corporate finance side.
How did our monthly payments not go towards the monthly premiums? Again, like, I understand what you're showing me here, but there's not really that much details.
Nothing. There you go. That's how you do it. And more silence. Silence. When they're silent like this in court, when they're this silent, when they are this silent, that silent, you got them.
You're rocking with the best.
When they're that silent, you got them. Finish them. When they're that silent, I texted her at this moment and said, you ain't losing shit today. Good. Got him. Come on. More silence. More silence.
Counsel, I think this is becoming too complicated to be doing this on Zoom without having the records here. I think it needs to be done in person.
Okay.
Let's go ahead and just refer it back to the assigned judge so it can be done in person. And then the defendants can be present and actually look at the documents as they're tendered into evidence.
Second time they try to take the house.
Okay. So we'll basically continue the trial to be reset in front of the assigned judge. Is that something case management will facilitate? Okay, so the case managers will facilitate that and then send the notice for the new trial date.
Okay. Thank you, Your Honor.
All right. Very good.
Thank you, Your Honor. Have a good day.
Thank you, Your
You
Honor.
too.
Yeah. But you know what was really supposed to happen here? What was supposed to really happen in this moment? What was the judge really supposed to do in this moment instead of continuing the trial? What was the judge really supposed to do? She was supposed to dismiss it without prejudice right now in this moment. Shout out to 100K and all the other gifters. Shout out to 100K. The judge was supposed to dismiss it within trial. So now I'm going to open the panel up for a second. I'm going to open the panel up for a second. And y'all want to give y'all thoughts or whatever y'all take on, what you just heard. What's up, y'all? Official 100K Freedom. What's going on, y'all? Oh, okay. Well, you can stay or drop whatever you want to do. Yeah, I'll stay. Yeah. Freedom, what's going on? 100K, what's good?
Man, that's textbook, man.
Yeah, but
if that was anybody else, that was a lack of sufficient evidence. There was no material fact there.
Man,
bro, that's gone. That's a goner.
Right.
You already know it too.
Right.
Review of business. Your personal knowledge by a review of business records alone doesn't establish personal knowledge.
Right.
It's reviewing off of something else. So it's like, damn. But you can kind of see like the judge is throwing like a lifeline and shit, trying to save the attorney.
Man, what, bruh? This was just the low end of it. The first hour, she didn't record the first hour. Remember, this is after we came back from. She passed the matter, so this is like an hour and a half later. So when we came back, the first hour, it was worse.
So was it like the first hour, like they already knew like y'all won't get nowhere, so they already like, nah, we're gonna need some more time to.
That's what the judge was saying because we went over the script. Were you there when the loan was committed? Was you there when the files were integrated? No. Was you there when no? So off the break, we had about 4 no's that to the questions that related to personal knowledge. After the 4th no, that's when the lawyer stepped in. Your Honor, we're going to object. We're going to object. We have the established amount, and plus, the defendants are still in default.
Yeah, that's the only.
That's it. That's it.
Going to try to focus on what you know they owe us.
Right.
It's harder. It's harder to get out of because they do focus, but you can still win it.
Right. Yeah. But I'm saying, but she didn't. Once again, when she came to me, she already went through 4 sovereign citizen gurus. I had her go withdraw 65 entries on the record, notice of trespass, tax forms, and I mean a whole bunch of shit, to the point where the judge ordered her by like September 25th last year to actually respond to the complaint of affirmative defenses, and denials and whatever. It wasn't until March when I finally looked at the record and seen the order. I was like, yo, did you ever respond to the complaint? And she's like, yeah. I said, let me see the response. She sent me that notice of trespass. I say, that's not a goddamn response. You didn't even respond to the complaint from a legal standpoint. So I rushed to, let me, Your Honor, we made a mistake, excusable neglect. We fixed the error. We had a hearing set for in May. And the other side, and I told him before the hearing, said, the judge might deny this because you waited like 4 months. And it was that sovereign citizen crap on the record. And then there was motions to strike that stuff. So the judge we get in there, and the other side, she let me know what they said. The other side brought it up. Your Honor, they wait till almost 4 months now to want to finally start to comply with your order. So the judge, after hearing like 5 minutes, now I'm going to deny the motion. I mean, I was like, damn, because it kind of keeps us in a defensive mode. We can't really get on the attack. But I knew that a summary judgment does not admit unliquidated damages. So they still got to prove the damages. They still got to prove the amounts due. So I already knew we still had that. So I'm like, okay, this is the lane that we're going to have to. It's good thing it's one of my specialties, but this is kind of the other lane. Now we're going to we were supposed to have a joint hearing to continue the trial, and hear the new motion for amended to leave and respond to the complaint. But the lawyer that y'all heard, she conveniently had a medical procedure on July 10th, the same day the trial was supposed to continue to. So she asked for a 45-day continuance until September 1st. So to go back September 1st. But I have these new exhibits and and we're going to revisit the motion, the amend, to leave to file the complaint. We're going to be like, Your Honor, they had 2 bites at the apple. It's like, how many bites at the apple y'all going to keep giving them? So, yeah. But, yeah, man, she was in a tight spot, man. She was in a tight spot. She was in a very tight spot. I mean, y'all should have seen some of the filings they had her do, man. It was just like, oh, my God. This is going to
show how harmful they are, too.
Man, what?
I have somebody who put in some soft shit recently. She hit me up yesterday, like they want us to respond to a hearing on it was about using AI as well. That they need to disclose what they're using AI for, how they're using AI. They need to put a summary. They need to put a summary of it at the beginning or the end. And they put in some secured party creditor shit. The bitch was 33 pages long.
Oh God!
They took they took that off the record, or they excused it because it was a garnishment hearing. It's a garnishment case at this point. She defaulted already, and they said that you as a defendant don't need to respond, so there's no reason to put this in. I was like, oh shit! But the only thing we got on them is they put on the certificate of service that they served her July 21st or some shit. Should they serve the company? So it's either 3 days after the company was served or 5 days after the initial hearing was filed. And so on the third day, they marked that certificate of service. Why she got the mail in the letter in the mail the next day postmarked for a day after the due date? So
wow,
that's a procedural defect right there.
It looks like your only procedural defect, because if you want to attack anything else, you have to attack the underlying default. Right.
Yeah, which usually, unless it's a good reason, like
they're not going. Yeah.
Reason to get it
yeah, they're not going. Yeah, they're not. It's very, once it's a garnishment order and it's you gotta. Yeah, it's so you gotta just
at
go.
This point, it's way easier to get the garnishment off and then worry about the other shit later.
And this is the note.
With that defect.
Yeah, with the servicing. Yeah, because that establishes a subject matter jurisdiction with the servicing. Proper servicing, yeah, you get it there, but boy, they play these vicious. These are part of the nuances of court. I be telling you, man, they all think it's so easy. I be like, man, sometimes, man, yeah, I don't, man, that in court shit, boy, whoa, way, good God Almighty, that shit can get nuancey. But I've never seen a judge do that much answering questions for them. I've never seen that. I've never seen that. I've seen judges
The other side, like she was part of the other side.
right. That I've never seen it from that standpoint. I've only seen it when the judge is interjecting on behalf of the pro se litigant, or kind of helping them out. I've seen that in open court, like the judge is helping them out, overruling objections that they clearly should have sustained. You get what I'm saying? Like giving them a chance to answer the questions, and interjecting when the lawyer objects, and interjecting on behalf of the pro say, nah, I think they meant this, so I'm allowed to. I'm like, oh shit, you get love. I never seen it on the other side, from a licensed attorney to pro se litigants.
These licensed attorneys, well, some of them be knowledgeable as fuck, but some of them just be straight ass.
Yo, these attorneys don't have, or their witnesses don't have firsthand knowledge of these numbers. They just get right. It's impossible. They just get the numbers from the ones that's suing. They just give them a printout. All right, these are the numbers, and they just go and argue it. This is why she just kept reading from a screen. That's all they're gonna do. Read from a screen. I mean, shit. Yes, sir. Yes, sir. So, yes, sir, True Seeker. But yeah, we'll be prepared for September 1st. I don't think, any new numbers that they come with, the game plan is not changing at this point. They haven't even reconciled the last balance. What you want to do? It's not the balance that I'm more worried about. They're not explaining the new additions to the new numbers. You get what I'm saying? They're not explaining how. They're not explaining why. And in the exhibits that should be filing with the court, there's still $1,700 that's unaccounted for from the recent customer activity report they just sent there in July. That's not $1 or $2 off, even though I think 100% all amounts have to be accurate. $1 off is too much to me, and I think under the Florida court rules it is. I don't know if they have a little threshold. I know for the federal standards and finance charge, if it's like 0.25% off, they can be liable. But I think accurate amounts due is accurate amounts due. I haven't read any case law where the judge gave leeway for $1 being off. Y'all let me know if y'all read it. I haven't. I'm not saying it's not out there. I just haven't read it. Yeah, they redacting the evidence. Motion to redact more evidence. And you know what's so crazy? On the amounts due in their Exhibit 5, it says amount due. That number was redacted. Like the number was clearly redacted. How do you have the amounts due number redacted? I never understood that. You have an amounts due number redacted. That made no sense. Made no economic sense at all. I never understood that. The amounts due number is redacted. Account history number redacted. They had so much stuff that was redacted. We like, hey, yo, Your Honor. Actually, let me show you what I'm talking about. Y'all can't see it on TikTok, but I'll be showing it on YouTube.
The only thing I can think of is maybe they caught their mistakes and they try to change it and just hope you guys didn't pick it up.
Right. Right. So YouTube, y'all can see total amount due. Total amount due redacted. But I've never understood that. I've never understood isn't the amounts due what you supposed to be like proven? You're supposed to have the numbers there. Why is it redacted? That was crazy.
Most of us, well, I'll say most people in this space though don't really pay attention to the detail of the paperwork. To be honest, like when you're skimming through, you're not really paying attention, and then most of the time they have you hone in so much on default, or you didn't make a payment, focus on the payment history.
Right.
So you're not really paying attention because you're already like, not I wouldn't even say the guilty conscious type deal because you know what I mean.
Right. Yeah.
You don't pay attention to it. You don't pay attention to the assignment paperwork if anybody signed at all. Anyway,
That's the human nature side of court. Remember, they say this online like it doesn't matter. It's still winnable. I'm not saying it's not winnable, but there is a human nature side of court to a person in default. The human nature side to the judges is if somebody is in default being sued, that means they must didn't pay. Y'all get what I'm saying? That's the initial, like, somebody must pay. Somebody owes somebody something. It took us almost 3 hours to get the judge to finally say, I'm tending to agree with the defendants. Almost 3 hours. So that means everything we were saying for the first two an hour, some change, you pretty much had your mind made up. That's pretty much what you were saying. Almost 3 hours in, now you start to agree. We've been attacking the same numbers and asking questions that you've been answering for them for at least hour and a half. And you know what, y'all, fellas? We never moved off the position for the numbers. We never moved. We never moved off the numbers. We was going down on that ship that day. We never moved off those numbers because there was nothing else to talk about. Of course, they're in default. Of course, there's a judicial default compounding the issue. There ain't nothing else to move. Remember, it's not like it was the beginning stages. Y'all get what I'm saying? It's not like it's the beginning stages where we can go over the, like all the stuff we doing now, we did for the beginning. Man, she was like 2 weeks before trial. But she came to me 2 weeks before the first summary judgment trial. And she didn't have the documents she needed to prove that she did actually respond to the complaint. And I say, use this angle. Even though this response is BS and the judge is not going to entertain that inspection of the note claim and all that crap and continuance, I said, did the judge respond to your filing, even though it's BS? She said, no. I said, okay. We're gonna go with the little arguments that we made, but when it gets too real, I want you to tell the judge when you get time to talk. I'm gonna send you a text. Keep by your phone when I tell you to raise it. So it was getting to the point, and I text. I say, go ahead, raise it. I said, Your Honor. She said, Your Honor, the judge never responded to my response to the complaint. And the same judge here, well, I don't see any evidence of a response. She couldn't even find the email that she got from the clerk letting know that the judge actually got it. And, she sent a copy of the response. So the judge about to take the house from her there. So I had to scramble. I said, oh, God, let me find this email for her. I sent her the email and I sent it to her and she forwarded to the clerk. And the lawyer and the judge came and said, she's right. I can't award summary judgment today. She did respond. The judge never responded. The judge never made a final order on it. Right after, like a week later, the judge denies that response. I said, look at this, like the original judge. So that's what saved her the first time. I'm like, girl, you got to have all your stuff ready to file and send on demand. She couldn't find it. I'm like, thank God I was there. So, and this was continued from March 12th to the hearing I just heard, which was like June, I think it's like June 12th hearing. So now it's September 1st. It's supposed to be July 10th. Now it's September 1st. So, but yeah, they play vicious games, man. And this is one of the reasons why I say, fellas, it may be hard, but if more people started pushing the same thing, if you had your first option, don't wait to be sued. If there's an issue, sue them first. There are the pro se space is not just a defense space. I know they want you to think it is, and it's not just a defense space. Oh, my bad. True Seeker, if you wanted to come up. It's not just a defense space, fellas, ladies and gentlemen. It's a plaintiff space so you can file too. Just like you'll file under the FCRA and FDCPA, just like you will file in, you can file suits there. Come on, man. Y'all know. Say it again.
I said it was crazy though. Even with those points, people think like we're talking a foreign language, because I was saying it before too. Like, you don't always have to be the plaintiff, but they're like, oh, you got to use your negotiable instruments, bill of it. I'm like, no. You can simply just send your correspondence while you're on there, ask questions, ask about the origination, ask those details, because that gives you a reason to take your ass in the court.
Right.
When you're not getting those answers. But it's like, oh no, you don't know what you're talking about. You're not supposed to go into court. I'm like, but if you're standing in honor, they don't have a defense. And think about it. Your Honor, I agree with everything I'm obligated to pay. I'm just looking for clarity.
Right.
You're just looking for clarity.
That's it. Now go ahead, brother.
I know that was really it. And that's always been my point. Just you're just looking for clarity about the numbers. You're not talking. You're not even going in there saying, "Oh yeah, you committed fraud against me. You did this."
Right.
No, because you still got to prove it. I'm
right.
looking for clarity, Your Honor. And then when you set that table up,
there you go. There you go.
They don't listen to me.
But even if that, oh my God, even if you're just going to court to seek clarity, that's the most important part of that is your account is in the green at the time you're seeking that clarity. So that strips their whole defense before they can get started. It strips the whole defense. They don't have breach of contract for non-payment. They don't have you're in default. Now they got to set and answer and respond to your claims. Now they got to. Yo, that is the best position. Remember, I made my final payment July 1st last year. By the time I filed the lawsuit, I was current. I didn't pay since July 1st. I was August, I ain't pay. September, I ain't pay, October. But they put my account on like a litigation hold for like 5 months till we settle. But still, during the whole course of the litigation, one thing that is their bread and butter is you're in default under the contract. That's their bread and butter. When you strip that away from them, I don't give a damn if you don't make the payment the next month. By the time you seek court or clarity on this accounting errors or these errors that you have, when you send it and when they don't respond, pay that next 60 days till you're ready to go into court. Then once you get into court, you can stop paying. As long as the time the lawsuit was filed, you are in the green.
I said the same exact thing.
The fuck?
You can do the only way, and I told people, if you're going to, even if you choose to disagree, you stop paying, at least put that money to the side. So if questions ever come up, you can still say, hey, I had questions, insecurities about this.
Yes.
I just want to make sure everything was an up and up, but I'm not going to pay everything in full today.
Yes. Yes.
Not just, oh, because they're going to ask.
Yes.
Why just not paying? Where'd that money go? Then it just looks like a money grab, but now it goes, okay, well, you're in default, like somebody who's just
right.
Get out of the scheme.
Right.
What the situation is.
That yes, brother. I've read, court guys, we read cases, we read so many cases. You don't like so many times the judge said, I remember this case verbatim. This lady made payments on her mortgage for 7 years straight. Now that she was in default. And I understand it was around, when times when the system was bad. Like I get it. Life happens it's happened to me more than once. I get it. But the judge said the plaintiff made payment on the account this day, made payment on this day, made payment this day. In fact, the plaintiff maintained a 7-year timely payment relationship with the defendant. Not one time during the course of her timely payments did she ever raise the claims that she's raising now now that she's in default. I was like, oh man. Yeah, that's what he said. Because if there is a breach of contract, you don't cure a breach of contract by not paying, by being in breach yourself. The person who brings a breach of contract claim or whatever, you know you have to be still in honor of the contract in order for you to say that they're in breach.
Yeah, you can do what is it? Repudiation.
Yes.
Only if you do your correspondence first, things like that. And then you have because even then you kind of have a meeting of the minds. It's kind of like, hey, but you let another party know, like, hey, I'm doing this because of this. But you still, right after that, you take your ass to court.
Yes. When you, I don't know if they understand this or not, but when you make the decision to stop paying, you are signaling litigation. There's no stop paying then administrative and negotiable instruments. There is that no. It is now litigation. If you want to send administrative documents, you still pay. When you stop paying, you don't go next step administrative documents. That means you've done all your investigation. You try to resolve this matter with them amicably, and they didn't want to budge. They kept gaslighting you, not responding. Now it becomes a legal issue. I mean, cases are decided based on the judges looking at the account. Like you get more credibility, especially, hey, Your Honor, I haven't paid them, but here's the money, 2 months payments or 3 months payments. I'm going to deposit this with the court escrow. Your credibility is going to be, you're going to get more credibility. Your claim is going to be taken more seriously, and the courts are not going to look at you as just an attempt to try to get out your obligations. I'm telling you, it matters.
And it's because the first person I ever helped in the space with mortgages was Michael Richardson. And he listened to me verbatim when I told him, make sure you stay in honor. And if you decide, because we went the repudiation route, if you decide to go that route, put that money to the side so if it comes up, then
yes,
you're trying to get out.
Yes.
He got his settlement.
Yeah.
And they gave back HOA fees.
Did they give him the did they give him the not title? Did they refund all his payments he ever made?
Yes. They gave him all his money back, all his cheese. He came on showing his check too. I think Ricky, I'm not sure if Freedom was around when he came on, but he got on that wagon. Well, okay, I can do this, so I can do all my bills too. And I was like, you can't save him then.
No, I don't. Fucked it all. Yeah.
It was that. It was, I'm trying to pay my bills, and you can do this. I'm like, that's not how this goes.
Nah, hell nah.
So I was like, no.
Nah. In many cases, it's so tricky. It's so tricky because there is no blueprint from one case to another. There's no blueprint. I look at every case is going to be settled on their own merits, on their own underlying claims. I believe that the results are going to be the facts and circumstances of this case, facts and circumstances of that case, facts and circumstances of this case, so forth, so forth. But I just don't understand why people want to play Russian roulette with their most important asset that they own is their home. Like, I don't understand the games people play with it. And I'm not talking about those. Oh, shit. Shout out to the finger. And shout out to, am I saying her name right? Losh. Is it Losh, brother? It's Losh, right? Losh. Shout out to Losh. Yeah, I don't know if it's, when life happens and, hey, man, I try to get a forbearance and I try to do the mitigation. I keep sending me through the ringer. I can understand, which I want me to do, things like that. But I'm talking about, listen, bro, there was this lady, I've known her for a while. She's been paying on her mortgage for 20 years. 20 years. Army vet. She's an retired Army vet, 20 years paying on a mortgage. Got with this trust, ecclesiastical ministry trust thing, and now she's in foreclosure. 20 years of equity going down the drain with commercial tort claims and fraud. I'm like, what happened to you?
It's these people out. It's not paying house. It's a whole crib on the line.
Right. That's a whole crib. It's a whole house. It's a whole asset. That's a bargaining chip with the world. That's something you could pass down. That's something you can responsibly borrow against.
Ain't crazy too, and it's VA. Like you can,
and it's VA.
There's no excuse for that. But, you know,
There's no,
circumstances.
yo, you an Army vet. You know how many programs they got? Like, come on. And you got a VA loan. Your interest rate probably ain't even that high.
My family military, so it's kind of like there's no excuse because that check is constantly coming.
Right. And you are retired. You get your military pay. I was like, oh my gosh. And I pleaded with her. I said, ma'am, at best, you can kind of just, you know, hey man, just expect the books just to see. It's just from an accounting standpoint. Maybe you're so good that any excess or unclassified interest or fees they charge, you would be good if they just put half of that to the principal. You would be good. Like, you don't even want nothing for free. Hey, just these misclassifications, just apply that to the principal, you be good. Like, you had so many, she has so many, you had to, you 20 years in, you pretty much done paid that motherfucker off already. To be honest with you, all them excess fees, you have the standing, and this is what I was telling her. I said, ma'am, we're going to go in, bust down the books, and just request for the proper reconciliation of the excess fees and stuff. We don't even have to get too technical, too deep. This is what you have looking in your favor. If we bring this claim in court, you are a military vet. You served this country. You did tours in Iraq. You have a 20-year on-time payment with these people. That human side of it, that's going to look good in your favor. Nah, she didn't want to hear it. I said, well, ma'am.
What happens a lot too, and I can speak for myself when I first came into some of this knowledge, and a lot of it was the wrong knowledge. But you get mad because you feel like somebody's taking something from you. You feel like, oh, they did this, they was doing all this all the time. So you get really emotional.
Yep.
So you get really emotional, and then you know what emotions lead you to.
Yep.
You do things you're not thinking clearly. You do things without really, doing your full due diligence. And so, as much as I've won, I've lost as well. So that's why I can speak from that.
Yeah.
I went in with the wrong arguments, and then I figured out right through some of the trials that, dang, what the world was I saying in the beginning? Like, this is crazy. Some of the things that went on for so long.
Yeah.
And then when I go back and look at it, I'm like, why did I say that in the beginning? So, again, being emotional, just jumping out and doing something, really understanding what you're doing fully.
Right.
For me, the whole part about the, rules and procedures, stuff like that was introduced to me through 100K. And that's when I realized, okay, I got to go in court and I got to attack I got to be knowledgeable of the procedures and see whether, where I can get in right there. Because again, a lot of them don't think you know nothing, so they just don't throw something at the wall and see if it sticks half the time. And then 100K also taught us, based on the amount, that's how hard they're gonna come. So I was in one. I had like 6 different lawyers on me for my mortgage. So it just depends. And you got to be, I'm working every day, and all they're doing in their office is on this case all day. So who do you think gonna have the upper hand? So a lot of the things people don't think through when they first jump in.
Yeah, man. Yeah, I tell everybody that's kind of like the first introduction when you get to this space is always going to be the sovereign way. It just is what it is at this point. That's the first introduction. But the most important part is knowing, be like, I see where I was at, I see where I did wrong, because that shows growth. If you're not growing in this space, you should not still at this state be hanging on to those frivolous claims that you learned when you first came to these spaces. Wins and losses are part of court. There is no such thing as a 100% win record. It's not the losses that matter. It's the, like, when I'm looking at this space, when I see people raising the same arguments that the courts have already universally rejected, that's been my own angle. That's the problem. That's the problem. Sometimes, and I've known, the balls ain't gonna bounce your way. I was a hair from beating the federal government in 2015. I was a hair away from beating them. Waived my right to appeal and everything. Did the colloquy, the knowing the intelligence, waived my right to appeal, and they still heard my appeal. And this sentence haunted me from the day. However, Thomas fails to raise these arguments in the district court. 5 years it took for them to rule on my appeal. 5 years. However, yeah, we got it. And I knew something was up because my case was held in abeyance to 2 other cases. First, it was United States versus Ali. And then they pretty much indirectly held my case in abeyance in United States versus Mathis. So I called the 4th Circuit Court of Appeals. I'm like, yo, what's going on in my case? I'm pretty much done. I just denied Ali. I just denied Mathis. She's like, no, your case is still going to, they're going to decide your case independently. I said, I'm like, oh, shit. I got like a year left. 2 weeks before I was about to go home. Thomas, you got legal mail. I read that order. I said, the opinion. I said, oh my God. But I did make it a constitutional claim. And I cited case law when you're making constitutional claims, you can raise it for the first time on appeal in the 4th Circuit. Because I knew I didn't raise it in front of them. So I said, Your Honor, I said, hey, I didn't raise this in the district court because of this. And the case I was relying on didn't come out till afterwards. But it's still a constitutional claim. Y'all should. Man, they said, you forgot you did not raise it in the district court. I said, almost had their ass. Yeah. You got to learn from. I was sick. I mean, I was 2 weeks out the door anyway, but it was just everything that comes with it. Getting your only thing I would have got back is no probation. And I probably would have, went straight out the door there. I still had to wait for the person to get the bus ticket and get all that stuff.
Then you could have hit them with the prosecution and some more shit.
Well, yeah, I probably wasn't going to take it that far, but the only thing I was going to win is just no probation. But I knew something was up because I'm like, damn, why is my case on abeyance for 5 years? Like, why is it 5 years on abeyance off a simple plea? And I torched them on it. And that one thing, procedural misstep, you forgot from that day forward, there ain't nothing that leaves that's missing the record from me. I don't even give a damn if it's not even a strong argument. There's going to be something procedural in there that I'm going to put it on the record. I'm going to put it on the record. I ain't nothing. Just in case I ever got to go on appeal, I'm going to make sure my appellate claims are preserved. And absolutely not. I learned from that order. Oh my gosh. Woo. Still makes me mad to this day. The government got slipped through the damn cracks, boy. Almost had them. Then they would have had to go back and overturn Mathis. They would have had to overturn Ali. I would have set new precedents in the 4th Circuit. So all those cases that were similar to mine, they just denied, they'd have had to go back and redo them. So I believe I got caught in a numbers game. And that happens especially in the criminal side of court. I got caught in the numbers game. Everybody was making the same arguments, and I pleaded with Mathis' attorney because we was at Beaumont together. I said, brother, look at my brief. Look, the aiding and abetting of a crime is not the elements of a crime of violence to substantiate a 924C enhancement. Aiding and abetting itself is not a crime of violence. Nobody else that was before me was making that argument. Thomas argues that aiding and abetting a Hobbs Act robbery is not a crime of violence for the purpose of a 924C. However, Thomas failed to raise this argument in the district court. I said, oh, that's how they're going to use to get me up out of here. Yeah, because they didn't say, oh, under Ali, you're done. Under Mathis, you're done. They heard my appeal independently. I knew I had something. Oh, yeah. Oh, yeah. My lawyer filed an Anders brief. That's basically saying you have no meritorious claims for appeal, but just because I'm your lawyer, you asked me to, I'm going to file it. Anders versus California, Anders brief. When your lawyer files an Anders brief, that means you ain't got, he don't believe you have anything there. He's just filing it because you asked him to. But in my pro se supplemental brief, that's what got my case held in the bands and where it's still for the next 5 years. Well, I'll drop the order, the August 2016 order. I'll drop the order. You said what? 5
years on appeal?
In federal court. Yes, sir. Yes, sir. I was on appeal I got sent to September 9, 2015, filed my notice of appeal and all that. They sent me that order August 1st, 2016. And damn near 15, when I filed my notice of appeal, 15, yeah. In about 2 weeks, so I was about to go to the halfway house. That's when I finally got the ruling. I was like, God damn, boy, they found a way. I said, it took y'all 5 years to tell me this. They overturned the government's motion to dismiss the appeal, citing the appeal waiver. They overruled the government. They rejected their motion to dismiss my appeal. Right. That's why I'm like, oh, y'all rejected the government's motion to dismiss my appeal, and I already took the plea and waived my right to appeal. Oh, there's something here. Shit, I thought so. I thought wrong. But yeah, back to the, with these civil transactions, man, it's a very, and these motherfuckers are dirty. They all play a dirty game. They all play a dirty, vicious game with the numbers on the books. They all play a dirty game. It's a dirty game. They all play a dirty, vicious game. You just got to get dirtier than them. Get dirty. Pay attention to the fine print.
Like I've heard attorneys say, no, we're just playing a game. We're just playing a game. Like, my life is a game?
Yeah.
You're good at this shit then?
Nah, it's never personal. So when the brother was saying earlier, like that's not an uncommon feeling in these space to feel like it's a personal attack, that they're like frauding you and it's fraud and they're doing something wrong to you. It's actually standard operating procedures. Like they don't look at you as nothing more than a receivables account. Like they're not going home and thinking about ways to make your life a living hell at night. Like they really don't give a damn about you. It's just business.
They don't give a fuck.
Yeah.
They're gonna get paid. They're gonna get paid. Then they look over their chicken.
Yeah, it's just business.
I mean, you know what I think it is? I think this shit is like kind of streamlined now. From like, you got people doing like the negotiable instruments, right? Like really trying to force these payments on the mortgage companies. It's putting people behind on their payments, and then that's what's like triggering these foreclosures. Because there's no other reason for people to stop paying.
You know what I think is going on? I think Oh, but I said it. You can give it to me. I think the foreclosure people who run to this side for foreclosure help, I think those are the negotiable instruments. I think those are don't pay and send this administrative document. Because it's always like pulling teeth. You ever talk to one of your clients on the phone and you try to get you ask them, well, what led to the default? How did we get here? They always start from, well, I filed some documents and then they, filed a foreclosure. I said, hold on. Think about who you're talking to now. You say you
skip the first notice,
right,
second notice,
right.
Let's talk about that because that's going to come up.
Right.
They just get here and they try to take your
right. And I said, and I always said it with this. I said, oh, that's what they did. I said, oh, we filed a lawsuit for unlawful foreclosure. There's no way. Oh, we're going to win this case. You was paying your mortgage on time, and all you did was just send a letter asking questions, and then they just foreclose on you for asking questions. Oh, yeah, no. It wasn't. No, it wasn't that. Oh. And that's what I used to force it out of them. I said, oh, no, we're going to change it's going to be a whole different suit now. Oh, well, I stopped paying because I did some research. I said, here we go. Yep, go ahead. That I was doing some research, another buzzword. That's another red flag. I was doing some research. That's a red flag. Anytime I hear that term, I was doing some research, that's a red flag. Well, I was doing some research. No. I guarantee you, your research had nothing more to do than documents that you can find on Scribd. A whole bunch of propaganda. What's that? Fraud stoppers and all that.
Lawful patriots. There's a whole bunch of these little
right.
And so there's not a lot of substance behind this stuff. And that's when I started referencing. It's like, y'all go and do research to see whoever tried these processes, because there's a ton of court cases. Like, if y'all legitimately go look, you see the same negotiable instruments, certified funds.
Same shit.
Rejected all that. Like, it wasn't a proper form of payment. And then you're talking about fraud, but look what you got on the record. You got a whole bunch of stuff that's trying to defraud a financial institution.
And you know what I don't like with these gurus? What really just puts them out? I would literally get a certified funds draft negotiable instrument. Hey, I got this from V Honey. We owe almost $500,000 to the IRS. Let me see that instrument she sent you. I'll go redact the information. Be like, damn, man, people owe $500,000 to the IRS now. I don't know what you're talking about doing it. Then I'll send her own work. And then you act like you don't know what that is. I'll be like, yo.
That's crazy. People are like, y'all see these people disappear?
Right.
They come on, pump these classes for like 5 months.
And then go.
6 months, class, week after week after week. Then all of a sudden you go.
Disappear.
Never on.
Disappear. Like, people try to come rebrand themselves. They go defect down to Telegram. Go die down for a minute because they hear the noise. Go die down. Then they come back with a new name. Like, let's go.
You popped in earlier trying to come in there.
I know.
Yeah, y'all gotta understand about the status, man. With the birth certificate, I'm like, don't come up here with that bullshit, bro. That's where a lot of it's like people don't understand, and it's like it's messed up because it comes off like, oh, we're rude. But it's like, no, you haven't been on those calls. You don't know what it feels like for people to have to be in a situation where they got to pack that house up and they got kids in there. They got to find somewhere to stay because they're listening to some stuff that you told them, and you're nowhere to be found.
She said somebody called from jail to tell his people. God damn it, man. Yeah, they come back. They'll come back with a whole new identity, just like Tori Martin. She trying to come back. I say that ain't even your real face on the avatar. You got some new trying to be indiscreet on the panel and shit. Trying to pop back up. You see her new name now, Tori. I gotta hold on. I mean, you're Tori Martin. Everybody know who you are. Always trying to hide. Motherfucker, always trying to hide. Come back with a new identity. And speaking of identity, has anyone seen Get It Done? I ain't seen him in a while.
He been pumping videos out. Where he been?
Oh, he probably got me blocked.
I haven't seen him either.
he disappeared because I used to always, he used to always looking post all his videos. I was like, I don't know.
I used to have fun with his videos. You say he lost his case?
Probation violation for a federal case.
Oh wow.
But those were the main ones. It's like a lot of stuff. Where's the application? Like it doesn't make a lot of sense. Like challenging the name, I never got that. And then the birth certificate, you gotta go after their bonds. It's like we make everything such a hostile situation.
Yeah.
Like it is
I got
always
into an argument with somebody about that shit yesterday. I think it was not even an argument, but I was just like, bro, you can't be that stupid. He said something about energy credits.
Oh God.
So energy credits, and it was something about crude or something like that. And she used the definition. I'm like, bro, that doesn't apply to you, bro. It doesn't work that way. And then she said her name, and she was like, and all the derivatives. I was like, that's not what a derivative of your name is. You can't just drop letters and say that's a derivative. It's literally your name dot initial, or your, like your middle name, first name, or your middle name, last name. I was like, those are derivatives. And then she was like, she was comparing it to financial derivatives too, because you're supposed to get money from it. I was like, bro, those are two different kinds of derivatives. What are you talking about?
Hey, bro, that's the same thing that this girl, Crypto, her name is Crypto Girl. That's the same thing that she was saying, oh, I got the derivatives. I got the CUSIP. The same thing. She was on my panel in 2024. I said, no, it's that. One thing I know about these people, they always, it's very interesting how they wear so many hats in this system, but barely can scrape two pennies and 3 dimes together to make 32 cents. Like they always I'm the investor. Oh no, I'm the certificated of the certification security holder. I'm the beneficiary of this. I'm the executor of this. It broke as a bag of glass. Ain't she, like, for real? It's like, God damn, how y'all all these exalted positions and you not benefiting from it in everyday life. I'm the executor of my estate.
His class, Freedom, you were in there. The dude came in there. He was like, "Yeah, he just paid Skip $1,500." I'm like, "You ain't here mad at me?" Because I had him in the backdrop. He was like, "Nah, man, Skip out here putting on game." I'm like, "So you paid a man $1,500 that has unlimited credit or unlimited money, right?" And I'm telling.
Hey, so I made a video about Skip. So people think that I just be talking shit about people. Now, I would literally take their own words and use against them like I do finance companies. So I broke down Skip the Boss whole 1099A video. I broke it all the way down. And then I get a random email like last year or 2024. Like, do you know Skip the... do you know Skip the Boss? I said, yeah, I made a video about him here. Well, he just scammed me and 8 other people for $3,000. And he just tried to get into my bank account. I said, how the hell? There's a real email I received. I said, how the hell does he get in your bank account? Well, he said he was going to help us get financing and stuff. And we gave him my social security number and stuff. So according to the person, because I still got the email starred to this day. According to the person, he has you sign like contracts with him, NDAs. You put your bank information and all that. And then he basically, be wise in my words because TikTok, but basically identity, and use your information to go get financing and financing right in other people's name. Like, like that.
That's a real whammer right there.
Right. So I was like, damn. So Skip the Boss got mad at me. I guess he's seen the live stream and he was going to lien my estate for $100 million. He said I'll be working for him for the rest of my life.
If you can find it, good luck.
Right. He's going to lien my estate. And, I said, well, nah, you ain't got to lien my estate. You can come lien me in real life. Like, no, we ain't got to do all that. Come lien me in real life. Let's go. Let's pull up so we can go together so you can lien me. Yeah. Let's do it together. Let's make it a joint venture. And of course, more threats about lien in my estate, and I'm gonna put a lien on you. Yeah, whatever. To this day, I haven't heard. I seen him once in a blue moon pop up on my timeline and watch. Okay, yes. What happened? Who did it? Mommy did it. You're mad at mommy? What do you want me to do? Want me to give mommy a spank? Okay. Want me get the belt and spank mommy? Okay. I'm gonna spank in 10 minutes, okay? Darren, what's good?
Chillin', man. Trying to get to this money.
Yeah, man. What's up, y'all?
Birth certificate and get your secured interest. I'm in deposit over there with the treasury.
Man.
Hey, yeah, I ain't gonna hold you.
If you put a lien on your own estate, you become the transmitting utility. You could potentially earn millions doing that.
Hey, someone was in the New Culture live center, like, just put some silver with it and then you'll be good.
Right. Hey, you know, I ain't gonna lie to you. What's the one that they doing today? Okay, so claiming the credits from the birth certificate. You know what? I'm about to try. So all I need is the numbers on my birth certificate, right? What else I need? And I'm gonna go find it and I'm gonna do my thorough research and report and I'm gonna put together. And I'm gonna come back and let y'all know what happened. Yeah.
Man, you can get my tumbo door. Hey, and that's because I was selling 100K. I was like, bro, Vince is following me now. He's trying to, I guess, hop on my live whenever he wants to.
He said you're not gonna find anything. Nah, you know who's starting to follow me too? From two different channels, and I blocked him for following me, removed him. That fucking dude that was with Tamika. What's his name? Dude with the bush. Caleb. Yeah. Caleb, man.
Oh, Ricky just showed me a video of him.
Man.
Yeah, I see you in the comment. Because that's the first thing I said. Talking about all the Form 56.
Man.
Like, bro, you the originator.
You was with that shit. He was with that shit.
If you're still doing this, you're outdated.
Nigga, I was like, nigga, you was doing it. Like this what happened. Core B. Check out the Core B show. She exposed them from top to bottom with the receipts on Tamika's prop. No. Yes, she did. She had thorough. And Kayla was on her live stream one night when he finally admitted that none of the stuff he did with Tamika worked. And then that purchase order joint. Tamika got a purchase order to make a purchase for a vehicle. And Jonah Bay was selling the same thing. And a lot of them was. And I told people, a purchase order is basically saying, I'm going to buy this vehicle with cash and I need to give me the purchase order so I can take it to my bank to wire the funds. No, it's not. You got to express the trust. So Tamika actually used real cash to purchase the vehicle and came online showing her vehicle like, hey, bloopty bloop, bloopty blur, bloopty bleepy deepy deepy deep. You want to get a purchase? You want to get a vehicle like this? Join the class. So she sold the class for $1,500, right? Based people thinking that just the purchase order, the money's coming from the treasury or whatever securities, converting it into a security or whatever, that they was going to be able to buy a vehicle. A person reached out to me from that class telling me that, yo, I'm so embarrassed because they went to the dealership to do that. And the dealership was talking about calling the police on her while she was there. He was like, this is fraud. You can only use a purchase. Like, where's the money coming from? So I was like, so she used a real life event because she knows that if she just would have said how she got the vehicle, it wasn't going to help anybody out. But this is the clients always create the culture of the space. Many people always want things that they don't have to pay for. And I understand why. Who wouldn't? Who wouldn't? The problem is that's only a fantasy that lives in that person's head. There's nothing in the United States of America where that is actually feasible. So it just shows the mindset of this culture, this space. Whenever you take the use of payment of money out and replace it with whatever, many people are going to jump on it.
Yeah, they got somebody else. I can't remember the name. Saying the same thing, getting money from paying yourself. I can't remember their name, but
paying yourself.
Yeah, it's like the same verb is just like, oh, you gotta pay yourself, and everybody's pushing that. Well, oh, why are you charging? And she's doing it for free. I'm like, not everything's free.
Then go to them for free. Then go there.
Frivolous violence. They'll follow behind on your payments.
Bro, that was on Jay Billionaires though.
Yeah, okay, yeah. That's a name. I'm like,
hey,
why are we pushing this narrative that we don't have to pay for nothing?
Let me ask yourself a question. Do y'all go to Walmart and tell them, let me get these products for free? Do y'all go to Google and tell them, let me get this products for free? A person, no, I'm just saying, if you could find wherever you go where you can get things for free, call your water bill, your electric bill, your mortgage, your auto, and call them and say, let me get this vehicle for free. And I say, if they give it to you for free, then yes, I'll give it to you for free. You can come to me for free. This is why I push back against these people with that, because they have no problem for paying for the things they want, but they always want to beg for the things they need. They always want to. They have no problem to come out the pocket for things they want for enjoyment and pleasure. But as soon as it comes to understanding and teaching and learning, oh, you should give it for free. No, the fuck I won't, because you know what you should do? You should go do it for free yourself. It costs you nothing but time and energy. Man, they better miss over here with that. Matter of fact, let me just say this last part. Let me just say this last part. I'm gonna get you my. If anybody comes to me that ever said, "Oh, you should do this for free," they're always immediately banned forever, banned from the channel, ever. Nah, for real. I don't give a fuck you talk shit about me. I don't block people like that unless you lie on me. But any that, oh, you should do this for, ban, up out of here. Go ahead.
No, I was just gonna say too, like, that's fair. And there was like, oh yeah, everybody, y'all, what were they trying to say? Oh, y'all mad, y'all losing clients. It's like, it's not really a clientele. Like, people do work in real life, but it's y'all chasing a ghost. And then when y'all get to a starting point, you want someone to feel bad. Like, they're trying to, oh yeah, you're charging. But I'm like, what I should be charging to get you out of that situation, I'm actually not. Even if it was 10%.
No,
let's say that if you did 10%.
Bruh.
What the situation was, you did 10% of a mortgage, 10% of an auto.
Bruh.
You could be charging that.
Hey, brother. Okay, so let's do this. Let's play a game.
That's not even bad.
Yeah, it's not bad. Let's play a game. Ricky, official Ricky, he's the one that he's the documents examiner. Freedom, you're the technical specialist. You make sure the draft's compliant. 100K, you are the one who's actually overseeing the drafting of the complaint. You kind of put the final touches on it. I come in as the accountant to run the numbers. Bruh, do you know that 100K, you got a client and you're listing me and my service, you're listing Freedom service, you're listing official Ricky services? Do you not know that, bro, I'm going to charge you $350 an hour? Like, that's just the standard, $350 an hour. If they was going to professionals, basically what I'm saying is you're going to get smacked in the head per hour. And once they're done, it's a billable phase. And there's a cap. You pay me every 10 hours I work on your case. $225 an hour, 3 hours. And then
include the paperwork. People don't understand that. The documentations too.
Right. Plus that. And then
you have people that have 500 some odd pages with because they filed their filings is like 100-something things going over the history of America. I'm like, those pages add up.
What is it, $10, $15 a page that you charge to go review? Like 10, 15 a page. So if you combine our understanding into one, you will be paying $750 to $1,500 an hour, and you're paying us at each stage. The initial filing stage, okay? Now it's the responding to the complaint stage. Now you got to pay for the discovery stage. Oh, it don't go our way. Now you got to pay for appeal. So these things, right? These things run 50 to 100, and depending on the complexities, it runs up to 300,000 in attorney's fees. So, especially in a mortgage litigation, especially on a complex nature, you can easily pay 25, 30,000. 5,000, 6, 7, 10,000 is love. But they're not looking at it like that. Because they're not. What?
I have someone right now with Freedom Mortgage. And I even know his attorney. His attorney was around. He out in Tennessee. He was around during the little mortgage crisis, so he knew exactly what the situation was. So one of the dudes came to me. We did the petition. He second guessed it, wasn't 100% sure, didn't really want to make the move. And just for him to give it to he paid the attorney, I think it was $10,000. Just for the attorney to say, hey, this was spot on. Did you go to somebody? Did you go to another law firm? I'm like, bro, it's the same. You just wasted $10,000 for him to tell you the same exact thing I was going to tell you. And they're struggling right now with the numbers, with the accounting, and with the assignment. The same thing I told him was going to happen because I helped him do his administrative process. Didn't want to listen.
I spoke to somebody who was going to an attorney who charged them they charged them $35 or $5,500 for 18 hours worth of work. Plus, he had to pay for phone calls. So he could, if he's calling them or they were calling each other, that's a whole separate billing. But $5,500 for 18 hours is fine.
And didn't even think about that because think about how many people pay that large lump sum in their retainer and you didn't see that man or woman until the day of trial.
And that
phone calls too.
Yeah.
You on my time to do Monday through Friday. Okay, they're going to tax you for that, and that's why I say you're going to burn through that retainer.
Bad.
First, it depends on how the pace of the case, but that retainer is going to be gone pretty quick.
Retainer will be gone fast. $10,000 retainer. My friends who's friends with the ex-SEC attorney don't even think about even getting a referral for him or any of his lawyer buddies, especially the more complex the case get, unless you got 10 to 15,000 just to retain them, like off the break, and no guarantees. That's just to retain me. Accountants upwards of $700 an hour to review your sheets, to review, no guarantees. You know how much money these corporate clients be paying to these people? And a lot of them going to just say the same shit that we say.
And not even that. They're like, hey, well, you know what? I think it probably be in your best interest to go ahead and settle out. Unless you want to refinance.
And that's pretty much what they're going to say. Yeah. They're not going to fight.
The standard is they have to be experts. If you're getting outside sources,
right,
they need to be experts.
They're not going to fight.
They cost money.
Y'all, they're not going to fight. There was this person I keep saying, hey, do you think you connect attorneys that help you? I be like, I gotta hear your financial situation. I'd be like, in my mind, you don't even have enough money to afford me. But the hell you think? Like you may pass out if I tell you what you need to bring to the table to him. You may need to.
It's just to get them on the phone.
On the phone.
Then you want them to review your case because remember you got to pay them for the initial meet and greet, and then they're going to review your stuff to see if they want to take it.
That's the whole right. That's the whole thing. Like you don't even understand how much, and I'm getting mine off the top just for having the connections to them. So add another $2,500 off on top of that. I'm gonna add to that. You ain't about to use my connections for free. That you got me, nah. Like people actually expect the whole package for like $200 because they value things based on what they can afford in the moment. But if it was something that they wanted to buy, they'll find a way to pay for it. That's human nature. They'll find a way to get it.
Oh yeah, like there was a lot of argument about spending $1,500 for a class to get unlimited money, and I'm like, if you really wanted, you could have spent that time buying law books, accounting books. You could have sat in a courtroom for free, got your feet wet, got get used to the environment a little bit. But y'all was chasing a ghost, like, and no one shows proof for it, just transcripts. At least on this side, we can show, okay, this is how a case goes. We can actually have some substance to it. We can actually, something tangible. Like, hey, here's a court order. This is how this gonna go.
Right.
Y'all have nothing. This is it's like a hope and dream.
Bruh, they got a better chance of accessing unlimited credit by building their corporate credit up, building their personal credit up, paying back their loans on time, and getting the extension line of credit and just keep it revolving. They got a better chance of what they think they chasing. That black card crap is a myth. Liquidating securities at the Treasury is a myth. Thinking you're going to cash an international promissory note and the International Bill of Exchange is a myth. By the way, just in case you're new to my channel, I better not see another teacher teach about an International Bill of Exchange or promissory note, because right there posted on my page, the same Uncitron United Nations Conventions website that you can go on to find the same thing. December 8th, 1988 is right there on my page. The United States never ratified the Uncitron Convention. It takes 10 countries to ratify it. You only got 5 that at least ascended to it. You don't even have the requisite countries to even make it full force in effect. And if you read the comments to UCC 1-201, you go down and read the comment, it said, the United States just completed a convention on international bills of exchange and international promissory notes. If the United States becomes a party to that convention, negotiable instruments will not be governed under Article 3 and will be governed under that convention. Given the fact that negotiable instruments are not governed under the Uncitron Convention and they're governed under the UCC state laws, that is direct evidence that international bills of exchange or promissory notes, I don't give a damn what verbiage you put on there. I don't give a damn which Federal Reserve account number you put on there. I don't give a damn what thumbprint you put on there. I don't give a damn you put executor, executrix, authenticated. I don't give a damn how many Title 18 laws, 18 USC, Section 8 that you put on there, how many statutes that you have all on. I don't give a damn. It has no legal validity in the United States and it's considered fraudulent.
They think, oh, they're being fraud. They're committing fraud against us, but not recognizing our documents. We're real people, and it's like, we want that to be true. But if you also if we really took a step back and looked at it, if this shit was true, why aren't people buying land and property at our
Why is it? I said the same thing last year. If this birth certificate stuff is so true, 100K, why isn't the wealth gap decreasing? Why don't you see multi-millionaires that you don't know how they came out for being a millionaire? They just pop up a millionaire. Because the reality is many people are going to have to work and maintain a job to sustain their livings or make smart investments or open their business and supplement their income that way. The notion that you're going to get out of that truck by this process, the notion that you're going to get off Section 8 from that process, the notion that you're going to increase your earnings from $45,000 a year to unlimited bottomless pit of money, it is only a reality that resides in your head. It's not the reality of the new world. You spent 12 years on the administrative process. You have gotten no closer to your intended goal than you were when you first got introduced to it. Give it up, accept the reality, and start living life from the hands, the cards that are in your hand at the moment, and make the best that you can do every day in life. Life is tough, comes a lot of curveballs. You're going to be up one minute, you're going to be down the next minute, you're going to be in between. You can have it all one day, you can lose it all the next day, you can get it all back the following day, and you can lose it all again the day after that. That's life. Roll with the punches, take the crookeds with the straights and just accept that this is how life works. But there is no way that you're going to climb to the top of a Fortune 500 millionaire through any process that's predicated on you are entitled to something just because you was born in the United States, just because you have a birth certificate. You are missing out on productive years of your life chasing these scams and these pipe dreams. You are purposely being unproductive because you think that bonded promissory note or that instrument that you just mailed off to the Treasury or that packet that you just mailed off that they've seen 5,000 different variations of it for the last 40 years and it's going to come back and manifest itself in a check. And then all those years you spent on the hamster wheel, you can make it all up while being success because now you have money to compensate for the years that you spent on the hamster wheel. You're going to spend more years on the hamster wheel. You'll become bitter. It's going to mess up your family relationships. And then it leads to you coming online, coming in the comments. It don't work. None of that work. None of that. You just trying to get free money. Oh, you trying to charge. Oh, you trying to sell something. Those are the bitter people who's been on the train too long, didn't get off at the stop they were supposed to. And now they think none of it works. They think everybody's trying to scam them. They think nobody. And these are, I can identify these people as soon as they start talking. They've had horrible experiences in these spaces, which nobody forced them to spend their money. Nobody forced them to go down those paths. They did it on their own because deep down inside, the underlying root for every person that follows this path is some form of desperation, some form of greed.
It's crazy. I'm not even trying to laugh about it, but when I was I was swiping through J Billionaire, and I popped in her live, and I seen John in there, and there was eating his ass alive because the lady was like, "Yeah, you was teaching your live for free, but you know, I was getting ready to be foreclosed on, and I had all this stuff going on. You wouldn't help me, and I didn't have any money." It's like. That mindset is just 21. Crazy. How you going to fault someone because they want to be compensated for their time, but at the same time, no one we didn't force anyone into that situation.
No.
Two, you had 3 attempts to come to me before. Like you have 3 different notices that go out, and I ain't let they do them right back to back. There's a gap between it. You have plenty of time to reach out.
Well, here's the thing. This is how the sequence goes. You already don't want to pay the bill because they hate not having money after they pay that bill. That's where the seed starts to grow. Always having to feel like they got to live paycheck to paycheck. What they don't understand is they're not as broke as they think they are because if they tally up those $20 impulse buys, still $50 for the shirt there, a little $10 they spent there. When they get their check, they go out, spend like $60 there. If you add all that up throughout the course of a year, that's about 3-4 racks that they spent on pure entertainment. Not saying don't enjoy your money, sit back and average, but if you add up all the little $5 here, the money that people spend and they don't think about, $10 here, $25 here, $8 here, $15 on DoorDash this week, $20 over here, $8 at this, Chipotle, McDonald's, going to the movies. If you add all that up throughout the course of a year, that's thousands of dollars that you would have been in a surplus at the end of the year. So they already mad at the fact that they don't like that feeling of being paycheck to paycheck. So now psychologically, subconsciously, they're like, damn, I don't want to pay this bill. So now this is where I did my research. It's not like they're doing any legitimate research. They're looking for a way to justify not paying because they know in reality the inevitable when you don't pay. So now they hear someone says, you already got the money. You gave them something. They committed fraud against you. You're a billionaire. You have an account. This access it. So now they have that activating event there that justifies them not paying. So it goes from first month, didn't make the payment because they just didn't have the money to pay. But many people, when they don't have the money to pay, they feel embarrassed or ashamed or got too much pride. So they don't call the company, explain the situation to them. So they remain silent. So the second month comes, This is the part where they're actively doing their research, right? Past due for the second month. This is the research. So the third month, this is when you see the negotiable instrument. It's always about that third month of default. They pop up out the blue with a negotiable instrument or a coupon method. It's probably about the second or third month. Bam. That don't work. That don't work. That don't work. They keep sending administrative documents back and forth because now they believe that they were supposed to accept this because they had statutes on it. And their research says they got to accept it. So now they're upset and they start flooding with administrative documents, trying to scare them into accepting the instrument. Feeling the pressure. Hold on, what is it? Feeling the pressure that they're about to lose it all. That's when they'll reach out to a person like 100K, reach out to a person like me, reach out to like Freedom, like, hey, I need help. I'm facing this foreclosure. I'm facing this repossession. That's how it normally goes. Or, you know, anybody that I've said, that's how it goes. The thing about that is they will never tell you. They will never tell you about all the stuff that they sent to the people before they got to you. Because in this space, 5 gurus can put them in a tight spot. The 6th guru is responsible for the first 5 gurus. So if the 6th guru don't get the job done, they place the blame on the 6th guru, and they don't ever place the blame on the first 5 gurus.
Like that casket, be getting ready to get the last nail in it, and it's like, wow, like you look at, like you can't, like all this stuff on the record. There was stuff I seen that was for credit cards, that was for auto loans. I didn't see stuff for auto loans that they have what is it, qualified written requests for auto loans. I'm like, what are we doing out here? What are we doing? It's like you can't care that bad if you're not even doing your due diligence. Like you just, and they're buying paper, whether it's free or not, at least read over your documents, because at the end of the day, it's your house. It's not my house. It's not my car. It's not my credit card, and vice versa, anybody else. But if you're not taking the time to like, okay, let me see if this is legit.
I ain't gonna lie to you, bruh. Hey, 100K. My uncle, he is an investor, right? He buys commercial paper. So he gets that disclosure statements and stuff. So he shows me a lot of his disclosure statements. Bruh, it is so much fucking money in the ABS, MBS game, bro. It is so much fucking money. Like, you could tell, like, when, like, in the moments, like, in a particular pool, the underlining collateral is underperforming. That's the term that they use to tell the investors when a borrower is not making their payments in default. They'll say, hey, this section of the pool is underperforming for the month. That's, in case you have never seen investor relation documents from an actual investor, when they say it's like underperforming, that means the underlying borrowers are not making their payment default. But then they will still get all their payments on time because the mortgage companies and the autos companies, they purchase thousands of shares of the trust notes, not for their own pocket, but it's a risk retention that's regulated by the regulators. It's SEC, pretty much. So they got to purchase thousands of shares of their own securities to serve as a first loss buffer. So they'll liquidate their interest in it and give it on to the investors to make up the difference from what you're not paying. What they don't tell you is, what you probably won't know, is the amount that they had to pay for your share of your monthly payments, they're charging that back to you. That's why they call it an advance. They got to advance. So they're going to charge those advance back to you under the guise of a late fee. But if you see how the late fees skyrocket, is because they're charging you for them having to liquidate their interest in their own trust notes to pay the investors. Wicked. And I've seen that with my own eyes.
It's like a flaw.
Go ahead. Nah, for real, bro. That's wicked though, ain't it? Wicked. Like, that's crazy. You charging me. Like, that ain't got nothing to do with the contract alone. You doing that because that's just part of your regulatory requirements. Why you they throwing it back over. Yeah, bro. These people are wicked. They are wicked. Oh, y'all. 100K freedom. Fisher Ricky, Darren. My friend, his wife is recovering, being back good. She had a brain aneurysm. Woo-wee. He's the actual senior supervisor analyst for Fannie Mae. He's a senior supervisor. So he goes all, they send him all across the world to do presentations on the investor relations side and compliance side with the regulatories and how, if there's an issue with their, like the issues that we were raised against the lender, how that goes on the investor side, how it can affect their relationships with the investors. So the steps that they use to make sure that I will let y'all know the date, but he's actually going to give a presentation for my private class for because I asked him to do a sneak peek on, not from our side of the closing, but after we close, their relations in it. If y'all want to sit in on that class and be able to get some extra pointers, maybe some things you already know. I'm not saying you don't know, but if you want to sit in, I think it'll be a beneficial for all. Like, I'm not teaching the class, he's doing the presentation. I'm not teaching nothing. I'm sitting in the audience with everybody else with my pen and pad, and it's kind of like just a more insight on the things that we will have to search deep and hard to see. You get what I'm saying? To right. Yeah, right. Horse's mouth. Like, what happens in a refi? What happens to the original note in the refi? Things like that. What happens, like, from their standpoint, what a foreclosure really means from their standpoint. And I think that's be beneficial because you could pass, I could pass that insight, add it to your repertoire. You ain't really got to tell nobody about it, but you could kind of, add it to your repertoire. Like, oh, okay. All right. Oh, them the documents that they use. Let me see. That go there and discover. You get what I'm saying? Like, it gives you a little.
What's crazy though, even with that, like, even if you do a whole free show on live, how many people really want to sit in and look at it and listen to it? Because the work that's going to go into it,
Right.
even though you know it, you still got to execute on it.
Right. That's like, he's doing the presentation. I'm not. I don't. I gave him my proposed, like, hey, part of topics, but he's going to teach it like he does, because he trains other ones in that field and all that other technical stuff. So y'all want to sit in, I'll let y'all know the date, send y'all the link, if y'all want to sit in. If anybody else want to join, you can send me a DM. We supposed to have it July 14th, but his wife came down with a brain aneurysm like on the 10th or the 12th. So she's back. They're recovering in Florida, which is a blessing. Woo-wee. Brain aneurysm. God damn. What the hell? Yeah. Like, I was like, oh, shit. I mean, I ain't about to press you out about nothing right now, bro. You got more serious shit to worry about. And he, just doing it as a solid. I'm trying to get, because I, this is trying to, network professionals. If y'all, real estate, we got the real estate coming next, real estate developer gonna, he's going to give a class on, how to, put yourself in a position if you want to invest in real estate, things like that. He doesn't mind assisting anyone who's serious. He already has private lenders he's been dealing with for years. He just built 4 new homes down in Texas. So if you're looking to purchase a home and things like that, and you want to structure, purchase your home under the LLC and things like that, you can reach out to me. I'm not telling you what to do, how to do it, but I can forward you directly to him. That's pretty much what I'm saying. Like, you look, I don't middleman like shit like that. That's his specialty. I forward you directly to him, and we take it from there. And yeah, man, if y'all got any classes or something coming up, shoot me a holler. I'll sit in the audience and peek around, see what's going on. Let's see, sneak peek. Final words before we get up out of here tonight.
100K. Wait.
Man, as good as always. Like I said, experiences, transparency. That's the value right there, the transparency, because
Yeah.
a lot of
Yeah.
people hide behind the boogeyman.
Yeah.
But then it just shows, man, just the skill set.
Yeah.
And the 10 you were doing it, man. So like I said, keep pushing, bro. Like I said,
Yeah. Got to.
keep pushing.
Yeah. Motherfucker. Yeah. Oh, yeah. Everybody is scared, high losses. What the fuck you hiding the loss for? I mean, the top litigators done suffer the L. What you hiding your loss for? Instead of hide. No reason to hide your loss. I mean, if you losing on sovereign citizen arguments, then that's the problem. Anything outside that, the ball can bounce in a different direction. I mean, these are people who have that, I can tell they've never been like in court and see how it goes, see how the ball can bounce. You don't know how the ball is going to bounce until it lands in your position. You don't know how it's going to. Does anybody here know how a judge is going to rule on any claim you submit in front of them before they rule?
It's possible.
It's impossible. Even if you got the rules, procedure, all that, it's still impossible to know. Right. I mean,
yeah. See, that's plan A. Even on the flip side, you go into a plan like,
right.
Get my
Right.
You can't call it.
Nah, you can't call that shit. Hell nah. You could be confident, I believe, but you can't call it. And that's the thing that I want to, if I could eliminate from these spaces people promising, guaranteeing shit that they have no control over. Like we really, our control is how we prepare for court. That's it. You don't know how the judge is going to rule. You can get an idea and gauge based on your substantive law, and you can put yourself in the best position to win, and that's all you can do. The object is not the L's, it's how you lose and how you respond to it, because it takes courage to do this. Knowing going in that we don't know how the judge is going to rule. You don't know, there's a lot of variables that you don't have control over, and still having the courage to do it. That's a victory within itself. It takes courage to do this. Knowing that going in, you're either going to win or you're going to lose or you settle. So if you have the opportunity to settle. You have nothing to prove. If you have the opportunity to settle. Don't roll the dice, because you don't know what the outcome would be. A settlement is a guaranteed outcome under a binding contract that you sign under the settlement agreement. That's a guaranteed outcome.
Don't be greedy.
And don't be greedy. Don't be greedy.
That's such a bar.
Right. The settlement is guaranteed. That's a binding contract. If they breach it, you can get that contract enforced. Like if credit acceptance wouldn't never sent that title to me, I would have sued them and they would have had to pay me more now. You get what I'm saying? Like I have a binding agreement. If I try to bring a claim against them ever again in life, they'd be like, he's signed. He can never, ever bring a claim against us ever again in any capacity. You get what I'm saying? It goes both ways. Not me, not computer share, not our third parties, not administrators, not anybody that's connected to credit acceptance. I am barred from ever bringing a claim against them ever. Cool. You honor yours, I honor mine. Cool. Ladies and gentlemen, if you have a chance to settle with these people, get out of these people's way and settle. You don't have to prove nothing. If they're offering you a nice, decent settlement, take it, talk about it, celebrate it, and go about your way. Anybody that's telling you different, like Ellis Raspberry, oh, you settle, I'm going for the judgment. No, you're going to be working on your 5th amendment complaint. That's what's...
If anybody listens to that right now, I'm telling you, you're doing yourself a disservice.
Right.
I'm telling you, they're going to test your temperature. The first offer, when I'm saying I'll be greedy, I'm like, if it's not something that's reasonable, you can do a counter.
Right.
But as soon as you put some ridiculous number on the table,
it's it.
They're going to bring the whole table down and say, okay, we can be.
No, they're fighting now. They're fighting.
Get in blood.
Right. Get in blood. Now that's what you're going to say. Get in blood.
Yeah, there were some negotiations during the settlement. I'm like, nah, I want the language to look like this. They'd be like, hey, is this sufficient enough for you? I'm like, nah, change that I to it. Nah, I want this here. Okay, does this look sufficient to you? I want specific language that y'all gonna mail me that title. I know you said it's gonna come to me regardless. Put it in there. Okay. Right.
Okay, yeah, we'll do a 30-day check or
Right.
2 weeks.
Right. Within it was like everything was within 7. I think it was like within 10 days of the settlement. Whatever. Send that up. I want to end the break. And probably like in like 7-8 days, it came to me in the mail. Cool. So I made them redraft like 4 times to admit I need to make sure everything's protected. So I made a redraft 4 times. The lawyer just went back and is this good? Nah. Is this good now? Yeah. What about this one? Is this good? All right, we good. All right. Here's the final draft. Ready to file the stipulation of dismissal? Is it sufficient to you? Yep. All right, we'll file it. We got it from here. You ain't got to worry about nothing. You ain't got to sign nothing, file nothing. We got it from here. Cool. Settle. That's the name of the game. Settle first. Don't play games with these people. You can start off winning, knocking them out the park, and that shit can flip overnight. Don't play games. Courts can get wicked. It's a
gladiator sport.
Yes. They can, right. That shit can start off good. That shit can take a turn for the worse that you can't recover from. That shit can get wicked fast. Don't play games when you got a chance to exit with your head held high, because the settlement, that ain't nothing more than the company just giving it to you instead of the judge awarding it to you. The company's just giving it to you.
They don't want to take that hill, so it's like, you know what?
Right.
Just so like there's no liability on either side.
Right.
You don't want a liability, so go ahead and do it this way.
Yeah. That's the first thing I did. I said, no fault mentioned on either side. No liability. Because they're never going to admit it. They're never going to admit liability. And stop looking for the other side to validate what you sent to them is correct. Stop looking for them to say, oh, yeah, you're correct. They're never going to tell you you're right. They're never going to put it in writing. They're never going to. You have to know you're right. They're never going to substantiate. They're never going to confirm you. They're never going to validate you. Pro se litigants, stop looking for your adversary to validate you. Stop thinking they're supposed to respond like, oh, you know what? You're right. What you're saying is true. They never will, even if it's true to the T. So when you send it to them, you're just sending it to them to put them on notice. You're not sending it to them for them to look for a response or to be like, oh, yeah, what you paid for was correct. You didn't waste your money on it. Because that's what many people are looking for when they send it to them. I don't know what I spent for, but is this right? I want the finance company to say that I this is right. No. Go ahead, Freedom. No. Got anything to say? Final thought?
For 1635. Doesn't work.
Oh God. They're still doing that?
Oh, and here's the big one. 15 USD 1602L. When it says credit card, it does not mean license plate. Even should have gone.
Yes, sir. Real estate development. Put me on. Max Lee. Send me a DM and I will put you in contact with him. I will put you in contact. Y'all can take it from there. Official Ricky. Any final words?
Yes, sir. I enjoyed the live debate. The only thing I would want to say is coming from more of the student side or a client side, that probably be more of a client of you guys, is what you have to realize when you go into these courts, when you're talking about take the settlement, is that those judges, lawyers, and people in that courtroom, they have mortgages, they have car payments, and you're in there trying to get relief from that, and they're looking at it like, hey, I got to pay mine. Why do they think they don't got to pay theirs? So you know, they already have that in their head as well. So that's another reason, you know, you have to think about that when you go into these courts and understanding that, hey, they're regular people and they pay mortgages and they pay car payments and things like that. They have credit cards that they're paying every month. So they're looking at you like, hey, what makes him think that he can get out of this? So, you know, you have that already working against you. So, yeah, so if you get in there and you do your thing on the procedural side and you get a settlement, I consider it a win. I always say there's no losses, but there's just lessons. So I've learned a lot from losses that I've had. So again, guys, just stay in honor. That's really the main thing I want to say. Stay in honor, because you take all their defenses away. And I had to learn that the hard way. But stay in honor. But it was a pleasure being on the panel with you guys.
Hey, Ricky, I gotta give you the yeah, that was some bars right there. That was 100% bars right there. God damn. Woo. That was some bars right there. With that being said, hey brothers, this has been a good build. Contrary to popular belief, everybody thinks I'm just here to be a contrarian and disrupt everybody. Contrary to popular belief, that's not true. It's just I stand on what I stand on. I got a full understanding what works and don't work. And if you are a person that, from my seeing from your filings and being in your live and speaking to you, that you have an understanding and you're doing things correctly from the eyes what I can see, you will never hear me try to go at anyone, just try to get some clout or make a name. That's not my style. That's not my angle. I'm a person that I don't mind. I will network with anyone in this space if it makes sense and if it's beneficial for both sides. I have no complex. I'm supposed to be the top dog that knows everything. I don't have that complex. I don't think like that. I don't move like that. Because when you really try to get money in the real world, you got to network with others. You can't get money just trying to be solo and single fact at all. You got to network. You got to network. Your connections. You got to network with people. So appreciate the build. I appreciate it. If y'all haven't followed 100K Freedom, y'all can follow them at their respective channels. If you're looking for services and any other factions dealing with mortgage, autos, consumer financing, and documents reviews, of course, I offer services as well. 100K is a good source. Freedom's a good source. Another thing, y'all never see nobody promote nobody else on their channel. But like I said, I come from a different breed, different cloth. But yes, y'all can reach any one of the three. If you need combined help, hey, we gotta combine together. You got a super highly complex case, you can do that as well. But these brothers are knowledgeable, and I'm pretty sure that they will have you at least not getting rejected under a Rule 12b6 motion for failure to state a claim because they brought sovereign citizen claims. Anyone that's in my circle, anyone's in my circle, we pretty much think alike. We pretty much got the same mindset. We pretty much understand court the same way. So hit them in the DMs, hit me in the DMs, continue to grow, continue to prosper, take it one day at a time. With that being said, ladies and gentlemen, I'm going to end this live. TikTok has been real. Appreciate y'all, fellas.
Peace and love, man.
All right. YouTube, it's been real.
You're rocking with the best.
If you need assistance with your mortgage, if you are current right now, reach out. If you're in default, it's not the end of the world. We got to make them prove those balances. You can reach out. Autos, you can reach out. Even if you just need to look over your contract, audit those numbers, audit the record, all inquiries, thomaslegacy603@gmail.com. I want to thank you all for tuning in. It's been a good live. It's been a good productive day, productive night. And tomorrow we wake up, put our feet to the pavement, and strive for greatness. I will catch y'all on the next one.